here, as I believe that it is important to understand the government's intention behind the bill. The Sentencing Council's imposition of community and custodial sentences sentencing guideline helps judges, when sentencing an offender, to determine whether to impose a community order or a custodial sentence. In deciding which threshold has been met, judges are required by law to obtain a pre-sentence report, except in circumstances where the court considers such a report to be unnecessary. Pre-sentence reports are used to give the courts more context of the offending behaviour in a given case, to aid judges and magistrates in making informed sentencing decisions. The current imposition guideline makes clear that pre-sentence reports offer valuable assistance to the court when it decides whether to impose a community or custodial sentence. Under the last government, the Sentencing Council consulted on a revised imposition guideline. This guideline was due to come into effect on April the 1st of this year and includes additional guidance on when courts should request pre-sentence reports. It noted that pre-sentence reports will normally be considered necessary for certain offenders, including those from an ethnic, cultural or faith minority. In effect, this could have led to offenders receiving differential treatment in terms of access to pre-sentence reports based on their faith or the colour of their skin. These changes were welcomed by the previous administration. By contrast, both the Lord Chancellor and I have been clear that that would be unacceptable, not least for the victims who put their trust in the criminal justice system. Singling out one group over another undermines the idea that we all stand equal before the law, a principle that has been at the forefront of our justice system and our society for centuries. This is the position the Lord Chancellor communicated in person and in writing to the Sentencing Council. The Lord Chancellor first used her existing power, meeting the Sentencing Council's chair on the 13th of March, to ask to reconsider their approach. Unfortunately, the Council declined to amend the guideline significantly or reconsult on their approach. While the Sentencing Council remains of a different opinion from the Government, I'm grateful to the Sentencing Council's chair, Lord Justice Davis, for the engagement he has had with the Lord Chancellor and for the cordial conversations I know we will continue to have. I'm very thankful that, following their engagement, the Sentencing Council has paused implementation of the revised imposition guideline while Parliament has its say. I'm also grateful to the noble lords who have shared their expertise in this area with me. It is clear that the intention behind the Sentencing Council's changes to the guidelines was an honourable one, to address the inequalities in our justice system. The issue of disparities in the criminal justice system is a serious matter and one which this government is determined to address. However, this is a question of policy, one which must be addressed by government, accountable to the public and Parliament, and via the ballot box. As my lords will be aware, this issue has prompted debate here and the other place, and publicly on the correct roles and responsibilities of the Sentencing Council, which the Lord Chancellor is carefully reviewing and considering all options. I am sure there will be discussed more in your Lordship's House in the months ahead. However, I want to be clear that this is beyond the scope of the narrow bill at hand today. The Sentencing Council, although only 15 years old, holds an important position within the justice system, and any changes to its function and powers must be considered carefully. I know that several noble and learned lords have themselves had roles on the Sentencing Council and its predecessor, and will have valuable views to add as this is considered. It would not have been right to address this through this targeted and narrow legislation. I'm proud of our judiciary, and I know that they are the envy of the world, rightly respected for their independence, impartiality and fairness. I know that the Lord Chancellor takes an oath to defend the independence of the judiciary very seriously. I'd like to reassure my lords that nothing we are considering in terms of the future of the Sentencing Council will change the government's clear commitment to defend the rule of law. My lords, I want to turn now to what the bill does. Clause 1 amends Section 120 of the Coroners and Justice Act 2009. It provides that sentencing guidelines about pre-sentence reports may not include provision framed by reference to offenders' different personal characteristics, including race, religion, belief, or cultural background. This would mean that any existing guidelines on pre-sentence reports, which are framed by singling out personal characteristics, will cease to have effect. The Sentencing Council will therefore not be able to make such provision in future guidelines. The changes made by this clause therefore prevent the Sentencing Council making policy about when pre-sentence reports should be obtained. That would risk differential treatment before the law and would undermine public confidence in the criminal justice system. In bringing forward the bill, the government's objective is to help ensure equality before the law, so that offenders are treated according to their own individual circumstances and not by virtue of their membership of a particular group. We've therefore used the term personal characteristics within the bill to ensure sentencing guidelines about pre-sentence reports cannot include provision framed by reference to any specific personal characteristic of an offender. And we have accompanied this by listing some characteristics on the face of the bill, including race, religion or belief, or cultural background. However, this is a non-exhaustive list intended to give context to the term. The government intends that the bill also applies to a wider range of characteristics, including sex, gender identity, physical disabilities, and pregnancy. We have also used the term demographic cohort in the bill's explanatory notes to help provide additional context to the meaning of personal characteristics. My Lords, I would now like to make clear what the bill does not do. It does not interfere with the court's duties to obtain a pre-sentence report in appropriate cases. For example, those involving primary carers and victims of domestic abuse. To be clear, the bill does not interfere with the court's ability to request a pre-sentence report. The Sentencing Code is clear that courts must obtain pre-sentence reports unless they consider it unnecessary. The bill does not affect this presumption. The independent judiciary will retain discretion to make decisions about where pre-sentence reports are necessary based on the facts of the case. Nor does it stop the Sentencing Council from advising, in general terms, that pre-sentence reports should be sought in cases where the court would benefit from an assessment of an offender's personal circumstances. And, as detailed in the bill's explanatory notes, it does not change existing precedent where the courts have determined that pre-sentence reports are necessary or desirable. In cases such as Thompson, where the Court of Appeal recently emphasised their importance in sentencing pregnant women or women who have recently given birth. Meanly, in which the court referenced the value of pre-sentence report for young defendants. Or Kerr-Mackay, where the defendant had a traumatic upbringing, vulnerability, and was a victim of modern slavery. The court considered these factors meant a pre-sentence report should have been requested. Instead, the bill narrowly focuses on the issue at hand. My Lords, I welcome the use of pre-sentence reports, which are a valuable tool for sentencers in appropriate cases. The number of pre-sentence reports declined by 44% between 2013 and 2023. The probation service is under a huge amount of pressure, and this is indicative of wider capacity issues in the system. This government has acted quickly to create capacity within the probation service to ensure that our hard-working probation officers have more time for vital work such as this. We have announced plans to recruit a further 1,000 probation officers in the coming year, on top of the 1,300 extra probation officers recruited in the last financial year. I'm continuing to work with the probation service to ensure it is able to deliver a high and consistent standard of service. We're also working to better understand what drives disparities in the criminal justice system. The Sentencing Council itself has acknowledged that the causes of disparities in sentencing outcomes are unclear, and understanding the data is the key first step to deciding what we must do to address these disparities. As the Lord Chancellor set out during the bill's second reading in the other place, she has commissioned a review of the data held by the Ministry of Justice on disparities in the justice system. In terms of a timeline for the review, noble Lords can rest assured that we are working at pace on this and will update the House in due course. I would like to reassure my Lords that this is an issue the government takes incredibly seriously and is determined to address. However, this cannot be done at the expense of equality before the law. In conclusion, by preventing the Sentencing Council making guidelines on pre-sentence reports with reference to personal characteristics, this bill ensures that we all continue to stand equal before the law. I urge noble Lords to support the bill and the principle that drives it, that of equality before the law. I beg to move.
be now read a second time.
My Lords, it's a pleasure to have the opportunity to contribute to this very important debate, and I too welcome to the Minister to his place, and I too look forward very much to the maiden speech of the Noble Lady Baroness Nichols of Selby. I broadly welcome this legislation whilst regretting its necessity and the fact we've reached such an unsatisfactory juncture. I also would say that I'm indebted to Policy Exchange for their excellent paper on this issue, which is two-tier justice. The impasse between the Lord Chancellor and the Sentencing Council was significant in its problematic challenge to parliamentary sovereignty, its undermining of the faith and trust the public must have in the judicial system, and the concept of equal treatment under the law. And it further undermined the long-established and quite proper constitutional convention of judicial independence and the separation of powers between the judiciary, legislature and the executive. The imbroglio arose from the consultation process as sentencing guidelines over 2 years in duration, which culminated in January of this year. The Sentencing Council's willful refusal, enunciated in its letter to the Lord Chancellor on the 27th of March, to amend their proposed guidelines demonstrated an obtuse disregard for democratic proprieties and quite legitimate criticisms of their actions in formalising two-tier sentencing and differential treatment by the courts based on membership of ethnic, faith and cultural minorities. My Lords, this is at a time when the public is acutely aware and particularly mindful of the fairness and appropriateness or otherwise in a number of high-profile criminal cases as reported in the media. My Lords, this issue transcends party political differences. It's about whether an elected parliament, government ministers who are accountable to the electorate should be preeminent in setting policy in judicial and relevant other related matters. It's appropriate to make the point that pre-sentence reports are a vital tool for magistrates and judges, not least in securing a more comprehensive assessment of an offender and balancing the decision to impose a non-custodial or a term of imprisonment. The previous 2017 imposition guidelines quite rightly made no reference to different cohorts who should receive a pre-sentence report. The new guidelines reference gender, ethnicity, pregnancy, transgender status and addiction issues, as well as domestic abuse, modern slavery and grooming and other exploitation issues. The automatic granting of a pre-sentence report to some groups, but the availability only of discretionary powers to others was and is wrong. These proposals were divisive, racist and corrosive towards community cohesion. Essentially, if you're a white man who is not religious, you are or were under a material and substantive disadvantage in the proposed sentencing regime. And the Lord Chancellor was right to highlight this in her letter to the Chairman of the Sentencing Council, Lord Justice William Davis, on the 6th of March. The fundamental question is, why were these rules proposed, the new rules, and on what evidential basis? The Sentencing Council's, quote, imposition guideline review of the trend analysis report of 2023 found that, quote, for those groups with the larger volumes of offenders sentenced, there is predominantly no clear evidence of differential impacts of the imposition guideline, unquote. The Noble Lady Baroness Faulkner of Margravine, Chair of the Equalities and Human Rights Commission, was surely right to state on the 12th of March, quote, the correct constitutional position would be that a judge already has tools at their disposal to seek pre-sentencing reports, and that they do so based on an individual case, on a case-by-case basis, rather than categorising certain groups. And indeed, we have existing primary legislation which is in place to allow judges to discharge their duties quite properly with appropriate evidential discretion via the Sentencing Act of 2020. My Lords, the Sentencing Council consultation was flawed and inappropriate. dominated as it was by liberal, self-serving and partisan groups who disregarded the wider societal need for a criminal justice system which is fair, impartial, open and transparent. For the avoidance of doubt, it is not for a judge, however eminent, to unilaterally determine sentencing policy, especially when the Lord Chancellor objects. Parliament has never legislated for it, and it is clear that it is for the judiciary to interpret and apply the law and not to formulate policy on an ad hoc basis. It is for Parliament to set overarching sentencing policy and criminal justice policy, whilst remaining aloof from sentencing of individual offenders by trial judges and magistrates, and that also goes, of course, for the appellate courts. So Mr. Justice Davis's rationale was erroneous in interpreting the role of the Sentencing Council. In his letter to the Secretary of State for Justice, Lord Justice Davis referred to the consultation process, stating, quote, "It was decided that to remove the list would have been contrary to the majority view expressed by consultees." And of course that majority view, that there should be a specified list of groups who automatically receive a pre-sentence report amongst consultees, is unsurprising. The consultation process received 150 responses, of whom 40 were charity or non-governmental organisations. Of course, they've every right and perhaps a duty. People like the Prison Reform Trust, Clinks, the Centre for Women's Justice, the Howard League for Penal Reform, perfectly entitled to put forward their views. But the Sentencing Council should have perhaps had a more balanced view, rather than just looking at the majority of opinion in this particularly niche and narrow consultation. The role of the government, ministers and Parliament, I think, was misunderstood by the eminent Lord Justice Davis. He questioned whether it was in the power of the minister to amend Section 1 of the Coroners and Justice Act 2009, and in respect of proposing to the Sentencing Council that a sentencing guideline be prepared or revised by the Council, and whether it was appropriate in this case. Although the legal advice Lord Justice Davis intends to obtain has not, as I understand, been published, it would seem, on an ordinary reading of the legislation, given the words of the statute are plain and unequivocal, to be a novel approach if the Lord Chancellor was not permitted to propose a revision of the guideline. Lord Justice Davis also claims that the inclusion of specific cohorts in the imposition guideline is not, quote, a policy decision of any significance. But that is not the case. Even one as distinguished as Lord Justice Davis must understand, of course, that he cannot unilaterally determine, in opposition to the Lord Chancellor, a policy that the government is obliged to follow. He also says in his letter, rather oddly, quote, "All judges and magistrates are required to apply any relevant guidelines unless the interests of justice require otherwise. In practice, the guidelines form the backbone of every sentencing decision made throughout England and Wales. There is general acceptance of the guidelines by the judiciary because they emanate from an independent body on which, and this is an important bit, which judicial members are in the majority. The Council preserves the critical constitutional position of the independent judiciary in relation to sentencing." He also goes on to say, in criminal proceedings, where the offender is the subject of prosecution by the state should not determine the sentence imposed on an individual offender. If sentencing guidelines of whatever kind were to be dictated in any way by ministers of the Crown, this principle would be breached. My Lords, I believe that Lord Justice Davis is mistaken for the following reasons. First, the critical constitutional position of the independent judiciary relates to the sentencing of individual offenders and not the overarching policy. Secondly, Lord Justice Davis implies that the judiciary only accept and presumably only follow sentencing guidelines, quote, because they emanate from an independent body on which judicial members are in the majority. And I believe that is wrong, my Lords. Third, the letter from from the Lord Chancellor to Lord Justice Davis, which replying to does not state or even suggest that ministers should play any role in the sentences imposed on individual offenders. To suggest otherwise, as Lord Justice Davis does, is disingenuous, I would suggest. And fourthly and finally, the sense that courts are not part of the state, or they are part of the state, beg your pardon, is not only wrong, but by any ordinary understanding what the state consists of, but is explicitly contradicted by the courts and tribunals' judiciary's own website, which states, quote, "The justice system is one of the three branches of the state. The other two branches are the executive, or the government, and the legislature, which is the two houses of parliament." Presumably, when Lord Justice Davis refers to the state, he means the executive. My Lords, in conclusion, it is right that the government has taken swift action to legislate, but the minister should also explain and look to the workings of his department, given that in the 12 months to January 2025, senior officials from the Ministry of Justice attended meetings of the Sentencing Council when these proposals were put forward, and yet they did not alert ministers to the fact that the proposed guidelines would be completely unacceptable to ministers, both Conservative and Labour government ministers. It is right that we open up and more closely examine the workings and membership of the Sentencing Council, and it is subject to proper scrutiny, for instance, confirmation hearings in Parliament. My Lords, we must make sure something like this does not happen again. Guidelines for the future should be required to be confirmed via orders in Parliament before coming into effect. Finally, it is right that parliamentary sovereignty has been exerted in this case, whilst judicial independence remains protected. It has been a vital and timely intervention, and for that reason, I'm pleased on this occasion to support the bill.
Can I say how sorry I was to hear of the death of the noble and learned lord, whom I just think of as Terry Etherton. His words were always wise, measured and compassionate, and we'll miss him. More positively, we look forward to the maiden speech of the noble Baroness Nichols. A one-clause bill provoking such strong feelings, particularly when there's much actually we can agree on. But I have to say, our approach from the Liberal Democrat benches differs a good deal from that of of Lord Jackson. This must be one of those situations where one really doesn't want to start from here, not only because I'd like to rewind, but because we are expecting very soon the review of sentencing by David Gauke. That should be the basis for a debate about sentencing, because the debate needs to be wider than this bill. We're very concerned about fast-tracking this legislation, which we don't see as necessary and obviously not desirable. That's a constitutional point. I'm a member of the Constitution Committee. I think only my noble friend Lord Beath and I as members are able to talk today. That committee takes the view that the fast tracking is not necessary and says so in a report to the House, which was agreed at about noon today and was published at about the point when we started this debate. Obviously, the Minister's not going to be able to respond to it today, but I would urge that the MOJ does respond to the points made by the committee well before committee stage, so that it is properly before the House and considered. Pre-sentence reports are important and ideally should be for everyone, unless, of course, the court considers they're not necessary. But the probation service is very overstretched. The Lord Chancellor said she was clearing the way to, I quote, free up capacity in the probation service. So we'll be interested to know details of that, at what cost that might be to the service's other work, and that in itself deserves debate. The Justice and Home Affairs Committee of this House, in a report, Cutting Crime, Better Community Sentences, spent a little time on sentence reports. I was chairing the committee at the time. The Minister was very welcoming of the report when we debated it. I recall he said he'd read it 3 times. I suspect his workload is such that he doesn't manage that for many reports, but we appreciated that. We referred to pre-sentence reports and to their purpose, which we described as providing an expert assessment of the nature and causes of the offender's behaviour, the risk they pose, and to whom, and so on. My pages have got stuck together. That happens. Our witnesses to the committee raised concerns about the quality of reports, in part because of the pressures on the service, meaning that sentences, we took the view, did not have confidence in them as they should have. If a report falls short, it means the sentencer may not be able to consider an offender as an individual. We heard of PSRs based on what was happening in offenders' lives 8 or 9 months before, not taking into account steps they'd taken in that period. We were told in evidence of the view of them being a tick box exercise, not being done in meaningful, person-centred way. Sentences may include mental health treatment requirements and alcohol treatment requirements, both of which require the consent of the offender, and drug rehabilitation requirements, which require suitability conditions met by probation, making a recommendation to the court. For a sentence to be rehabilitative, one of the objectives of sentencing, it's obvious that the PSR process needs time and for the offender to be engaged. The committee said that they are an essential part of the sentencing process. They allow courts to tailor sentences to individual circumstances and give sentencers confidence that specific requirements are suitable and available, that's another matter, in their area. And the government agreed. I stress individual because one has surely to consider the whole person, and how do you do that while excluding characteristics? As well as agreeing on the importance of PSRs, most of us would agree, I think, on the importance of equality. But that does not mean starting from a point of equality. How can we ignore how people with some characteristics, those picked out in Clause 1 in particular, are overrepresented in the criminal justice system? The Sentencing Council acknowledges this in correspondence, and so does the Lord Chancellor. But then it's argued that differential treatment on the basis of race or ethnicity affords the principle of fair treatment before the law. Is fair really a synonym for equal? I take the view that one has to recognise where there is inequality in order to address it. And addressing it does not always, and not in this context, treating everyone the same. As the Sentencing Council notes, there are inequalities in the sentencing regime, for instance, age, which the bill does not spell out, though it, of course, comes within the non-exhaustive list, which is not on the face of the bill. The Council's view is that, I quote, providing a sentencer with as much information as possible about the offender is one means by which disparity might be addressed. Whilst the Council agreed with the government that any systemic issue relating to different ethnic outcomes would be a matter of policy, Lord Justice Davis, who's been referred to, said sentencers must still do all they can to avoid a difference in outcome based on ethnicity. Therefore, he said, judges would be better equipped to do that if they had as much information as possible about the offender. The Constitution Committee currently undertaking work on the rule of law, and I'm assured by those who are far more expert than me that positive measures are not necessarily incompatible with the rule of law. To me, the term personal characteristics without definition is confusing. To me, the division between characteristics and circumstances is very grey. What, for instance, is addiction? I think it's a characteristic. That would undermine treatment to which I've referred. The list, as I've said, is not exhaustive. That adds to the confusion. There is a risk, I think, of confusion of characteristics under this bill with protected characteristics defined for a different piece of legislation. The Constitution Committee is also critical of the bill because of the uncertainty, I might say, incoherence in this area. And I really look forward to the MOJ's response to the points that we make in the report. The committee also refers to retroactivity, which offends constitutionality. Can the Minister explain to the House what is to happen with pre-sentence reports which are currently or at the point when the bill becomes law, as I assume it will, what will happen to those that are in the pipeline, including reports which have been prepared but are not yet before the court? Are they to be reviewed? Are they to be rewritten? I think that it is really quite confusing to fast-track a bill to such an extent that commencement is immediate. Normally, there is time for those affected by legislation to prepare. I keep coming back in my mind to the question of how one can sentence without recognising the whole person. I also wonder how one can amend a one-clause bill without being accused of wrecking it. But I know that my noble friend has been thinking about this very carefully, and I'm hopeful we will find a way which would make it a bill which is both coherent and accessible. I wish not only for procedural reasons, but because the focus should be on effective, trusted system. I wish that we weren't starting from here, and I hope that this is not the finishing point.
Yeah. Really good.
Very briefly, to the remarks of Baroness Henry about the late Lord Etherton. He was a lawyer of the highest ability. He had great skill and was a man of real quality. I worked with him for many years at the bar and as a colleague on the bench, and all those qualities were shown in abundance in what he achieved in that period. But he also achieved a great deal in this House and took on a number of causes which some might not have found popular. He was a great man and he will be greatly, greatly missed. But could I turn very briefly to make 3 points about this bill? First, although we've been accorded a long time to speak, I don't intend to take advantage of that to repeat what I have already said at length prior to the Easter recess. I then explained why I thought this bill was not necessary. I regret that the government feels it is necessary, but I very much hope then, and I still hope today, that this issue can be resolved without legislation. But I won't repeat what I've already said to that end. Secondly, I agree with the Minister that this is a very, very narrow bill. That is no excuse for not getting it right, but it is a narrow bill. But what I think is important to note, that it is not the occasion for the kind of wide-ranging issues to be raised, such as those raised by Lord Jackson of Peterborough. I do not therefore intend to answer them. If they are raised at a subsequent occasion, that will be the appropriate time. But this is a narrow bill, and I say that because I think it is important that the Sentencing Council and its predecessor bodies, the Sentencing Guideline Council and the Sentencing Advisory Panel, have worked well, though I ought to declare that I was a member of the Sentencing Guidelines Council, had a hand in setting up the Sentencing Council, and was its president for 4 years until 2017. But I do not believe that if we look at what it has done, we analyse the constitutional position, there is any basis for making any real change. It has been a great success as it brings together the two arms of the state, the judiciary and the executive, under the supervision of the third arm, Parliament, in producing what is a very sensible way of dealing with balancing the role of Parliament in setting policy and the role of the judiciary in sentencing individuals. But that is a complex issue, and I would like to leave it for an occasion where it properly arises. It does not arise today. Thirdly, and this point does arise today, and that is the definition of personal characteristics. This has already been touched on by Baroness Henry. I think I would put it this way. I think it could, with advantage, be clarified. And I think it would be helpful to understand why the definition is different to the definition of protected characteristics set out in Section 4 of the Equality Act. I note that the Minister has, in his opening speech, already referred to the remarks made by Senator Staken in the other place on the 30th of April, where he said, "We are clear that it is intended to cover a wide range of characteristics, including sex, gender identity, physical disabilities and pregnancy status." There are a lot of other characteristics, and I really do think it would be, before trying to amend it, it would be very helpful to have a clear explanation, and I've given the Minister notice of this, of why the course chosen has been chosen. But that is more important, I think, in the light of paragraph 14 of the explanatory notes, as it uses the term personal circumstances of individuals in apparent contradiction to personal characteristics. Now, I'm not sure that I understand the difference, but it would be helpful if the Minister could try and explain what the difference is. And in any event, with that explanation, we can look forward to amending, I hope with advantage, with considerable advantage, this part of the bill without anyone being accused of wrecking it.
Hear, hear.
I declare my interest as Anglican Bishop for Prisons, and I'm grateful to be speaking in this second reading debate. I too greatly look forward to the maiden speech of the noble lady Baroness Nichols. Having said that, I don't believe this is a debate we should be having at all, and I don't believe this rather theatrical piece of legislation is necessary. In a world of sufficient resources, as has already been said, there would be comprehensive pre-sentence reports for everyone, to which careful attention was paid in court. But if we have to prioritise PSRs, then it makes sense to prioritise those that we know are especially vulnerable or where there is evidence of disproportionate outcomes from the justice system. Would the noble Lord, the Minister, comment on why he thinks there was such shock at this apparent two-tier justice with regard to ethnicity, but not the other cohorts in the guidance, such as young adults and pregnant women? Does government believe the issues raised in the landmark report by the current Foreign Secretary almost 8 years ago are now a thing of the past? Is there no role for judges in mitigating the issues raised in that report? The use of the Sentencing Council guidelines to apparently feed a culture war is distressing. And the allegation of two-tier sentencing based around race, religion, belief or cultural background is so damaging to public understanding. This is already shaped so heavily by media headlines and the shocking and extreme cases of violent crimes, which are not the norm. Public understanding of why and how criminal sentences are handed down is severely lacking, as is evidenced in the Justice Select Committee in 2023 and a recent Prison Reform Trust report detailing a citizen jury exercise. My own experience of talking to teenagers in schools is that more information about sentencing results in more considered responses and a greater sense of engagement with what we are trying to achieve, which surely goes beyond mere punishment. My Lords, at the heart of the Christian gospel is a God who holds together both justice and mercy. We need a big, long-term vision. Surely long-term vision must be about transforming lives and communities, and that includes victims as well as offenders, recognising that many offenders are also victims. And if we are committed to the transformation of society, we need to take account of the impact of sentencing on families and the wider community. I'm not saying that people who commit crimes should not receive punishment, but I am saying that sentencing should be much more than this and give the best possible outcomes for society. In a recent judicial critique focused on sentence inflation, 4 former Lords Chief Justice, including the noble and learned Lord Thomas, highlight that people in prison are individuals, not statistics, and that, I quote, "The consequences of imprisonment on people's lives in prison and upon return to the community need to be considered in the whole." And they go on to say that evidence suggests that what happens during and after a sentence, including rehabilitative interventions and resettlement support, is more important than sentence length. If we are to treat people in the justice system as individuals, that surely includes taking into account people's circumstances, such as whether or not a woman is pregnant, and indeed their characteristics, such as neurodiversity, and I echo what's been said about characteristics. We cannot pretend that circumstances and characteristics do not matter. Wise sentencing is threatened by this am-dram politics, and this bill risks taking us backwards, not forwards. I firmly believe we need less political control over sentencing, not more. I would urge the noble Lord to revisit the House of Commons Justice Select Committee's 2023 recommendation of the establishment of an independent advisory body on sentencing, and I would propose an additional step: a commitment from the Treasury set out to Parliament where ministers propose to expand or lengthen custodial sentences against recommendations from the advisory board, thus resetting the relationship between politics and justice, including the public purse. There is more I could say, much more, but I will end with engaging with the government's own rationale for this legislation. The Justice Secretary says inequality in society is a matter for policy and not for the judiciary. How then will the government create an equal society over their term of office so that these guidelines become redundant?
Thank you, my Lords. It's a profound honour to rise before you today and make my maiden speech in this esteemed chamber. I'm deeply grateful to my sponsors, my noble friends Baroness Anderson and Baroness Winterton, and to Black Rod and all of the House staff who have been so welcoming since my introduction, particularly the doorkeepers. And I'm grateful also to my noble friends, the leader Baroness Smith and the Chief Whip Lord Kennedy, for their personal support since my peerage was announced. To be asked to join your Lordship's house is a privilege I do not take lightly, and I intend to serve with the same dedication that has guided me throughout my life. My journey to this moment has been shaped in my roots in Selby, in North Yorkshire, a place that has defined who I am and the values I hold dear. It is a town built in industry, hard work and community, a place where people look out to one another, where solidarity isn't just a word, but a way of life. My connection to Selby runs deep. My father was born there, though his life was not always kind to him. His mother died from tuberculosis when he was 6 years old, and she was laid to rest in a pauper's grave in Selby Cemetery, a stark reminder of the struggle so many families faced. My mother, one of 10 children from Spennymoor in County Durham, also knew hardship. Her father, a miner, lost his sight in a pit accident, yet even through adversity, my parents found strength, love and purpose. They met during the Second World War. My father stationed at Burfield Common. My mother evacuated nearby. They married, settled in Selby and raised a family in a council house on one of the largest estates in the town. Their values, community resilience and public service shaped my own path in life. It was there that I attended Selby Abbey Primary School, following in my family's footsteps. I recently visited the Year 6 group who wanted to know about the House of Lords. My early years were filled with memories of the shipyard, yes, my lords, a shipyard on the banks of the River Ouse. The sight of workers leaving on bicycles as the buzzer sounded, a scene that spoke of industry and pride. But perhaps my most memorable early experience was the time my mother, after a long walk into town, returned home only for my father to ask, "Where's Wendy?" To her horror, she had left me outside Woolworths in my pram. Thankfully, I was still there, blissfully unaware that I had been momentarily misplaced. My professional journey took me from catering college in Leeds and York. I became a school meals cook, then started work in the kitchens of a pit-top canteen at one of the 5 super pits around Selby, and later moved into residential care for the elderly, following in my parents' footsteps once more. It was Carrington House, formerly a workhouse, that I truly found my calling. I saw firsthand the importance of dignity and care and the power of collective action to bring about change. It was there that I became active in the National Union of Public Employees, which later became Unison. For over 4 decades, I have worked for North Yorkshire Council, during which I have fought for the rights of working people, serving as branch secretary in North Yorkshire, and in 2015-2016 serving as president of Unison. Public service has always been in my blood. Like my parents before me, I became a Labour councillor. Though my route to office was far from convenient, in 1999, a miscounted vote led to an incorrect result being declared. It took a trip to the High Court and the oversight of a judge to correct the mistake. A moment I will never forget. He turned to me at the end and said, "I've always wanted to say these words. I hereby declare Wendy Ruth Nichols duly elected." That experience taught me that democracy is precious, but it also requires vigilance. Beyond local government, I had the privilege of serving on the National Executive Committee of the Labour Party for nearly 14 years, including some of our most challenging times in our party and our party's history. I'm proud of that work because I believe politics should be about service, about building a fairer society, and about ensuring that those who come after us inherit something better. As I take my place in your Lordship's house, I do so with immense gratitude, but also a sense of personal loss. My husband Keith, a proud railwayman and a trade unionist, passed away in 2008. My parents, who shaped so much of who I am, died within a month of each other in 2009. I wish they could be here to see this moment, to share in this honour, but I know they are with me in spirit, just as I know that my greatest legacy lies not in titles, robes or offices, but in my children, Rachel and Sean, my daughter-in-law Jenny, and my 6 wonderful grandchildren, Brandon, Fiona, Libby, Ella, Michael and Amy. My Lords, now turning to the debate. Again, something of great interest to me. I have over the years represented many of our members in the probation service and have seen the amount of work that they have to do. So whilst PSRs themselves are not an indication of sentence, we know there is evidence that they're an important element in sentencing. Receiving a PSR is more likely to discourage a judge from sending an offender to prison and therefore will help reduce pressure on prison numbers. We know there are inequalities and disparities in society and our justice system which must be addressed. But these guidelines amount to treating people differently before the law, according to their race or their religion. This breaks an ideal that our justice system is built upon, equality for all before the law. One of our most closely held ideals is equality before the law, and that we can never have two-tier justice because it completely undermines public confidence. Clearly, the Sentencing Council is straying into matters of policy in trying to correct for racial disparities using differential treatment methods. Pre-sentencing reports are very important to give the judge as much information about the offender as possible and can cut levels of reoffending when used properly. However, do you agree with me that they should be available for all offenders and access to a pre-sentencing report should not be determined by an offender's ethnicity, culture or faith? Pre-sentencing reports are important, but very often probation is stretched so thin. Officers don't have time to complete them. What is the government going to do to ensure that where a PSR is required, a request probation service will have the capacity to do that? I note that the bill removes the whole problematic section of the guidelines, but the Lord Chancellor has been clear that pregnant women or victims of domestic abuse would still much be expected to have a pre-sentence report. So, my Lords, I look forward to working with you all in the months and years ahead. I bring with me the values of Selby, community, fairness and a belief that we all do better when we stand together. I thank you for your time and your welcome, and I look forward to playing my part in this great institution. The path from the pit-top canteen to the red benches of this House has been eventful, and I have no doubt that the next chapter will be just as remarkable.
Well done. Brilliant.
My Lords, it's an honour as well as a pleasure to be the first to congratulate my noble friend on her outstanding, and if I may say so, very moving maiden speech. She brings to this House deep experience and wisdom. She and her loving family have met challenges and setbacks that many in this House will not have experienced. She has faced adversity and knows as well as anyone what it's like to be brought up, to work, to live in a world where people don't always enjoy the good things many of us in this House take for granted and have always taken for granted. In her speech, it's clear that she understands deeply how people experience life. Her brilliant reputation from her union work with NUPE and then with Unison, I think shows that absolutely clearly, and there will be many in Selby and beyond who owe a huge amount to her hard work and commitment. She told us in her speech that her values are community, resilience and public service. Whether it's been working for her constituents when she was a councillor, whether working for North Yorkshire Council for many, many years, whether her work for Unison and her fellow workers, or performing her important and invaluable, and I mean invaluable, and many on this side will know exactly what I'm saying, her invaluable political work, she has truly lived up to her values. All of us who've had the honour of listening to her speech today look forward to hearing her many times in this House. My Lords, on the debate, I should declare some interests. The first is as Chair of the Leicester Community Advice and Law Centre. Secondly, as Joint Chair of the All-Party Group on Access to Justice. And thirdly, as a member of this House's Justice and Home Affairs Committee. Before making the few points I intend to make, I want to stress, and I think it needs to be stressed, how the Ministry of Justice under this government already has a record, in my view, to be proud of. Not only in the quality of its ministers, and I have to say, of course, particularly in this House, but in what, against crashing obstacles, they have already achieved. Given the ridiculous, unsatisfactory budget it has to work with, for me, the small but important increases in the legal aid area, and particularly the setting up of the Gork and Leveson reviews, are among their most significant achievements. However, I have to say, can't say that I am equally delighted to see this bill before the House this afternoon, taking up precious parliamentary time that could be spent legislating or at least debating other more vital justice issues. Frankly, I do find it hard to accept that we could not have resolved this impasse without the need for legislation, let alone fast-track legislation. After all, there is an overwhelming consensus as to the value and necessity of pre-sentence reports. In addition, there is surely widespread agreement that the Gork review, due out hopefully later this month, and the legislation that follows it will be of much greater significance than this bill as far as sentencing is concerned. It will also, of course, be relevant to the issues that we are discussing this afternoon at this second reading of this bill. The danger, it seems to me, is one of over-legislating. By not allowing something as broad as personal characteristics to be taken into account in sentencing, we may almost by accident be excluding other factors that are highly relevant to any sentencing decision. This takes me, my Lords, to an amendment moved but not voted on in the other place. It was in the name of the Honourable and Learned Member Jeremy Wright, a distinguished Attorney General in the coalition and succeeding Tory government. He argued cogently, it seems to me, that if anything that comes within the broad category of the term personal characteristics is forbidden from being considered by the Sentencing Council when setting out their guidelines, this could well cover other personal characteristics such as, and he mentioned physical or learning difficulties or severe injuries, which is surely not the intention of this bill and could make the difficult task of a sentencer even more difficult. Jeremy Wright suggested a change in wording to demographic cohort, thus giving ministers, in my view, their point, but not making the result confused or unintelligible. I'm attracted by this approach and hope that the government, following this second reading, will consider really carefully the proposition that Mr. Wright made, if not using his actual words. I want to make two final points, my Lords. Both the current chair of the Commons Justice Committee, Andy Slaughter MP, and his predecessor, Sir Bob Neal, have expressed regret that the bill and particularly the events leading up to it, have been used by some to undermine judicial independence and to allow ad hominem attacks on judges under the guise of belated objections to these guidelines. I agree entirely with the two chairs of the Commons Justice Committee. Alas, we are today, in other countries we see around the world, including, surprisingly, the United States of America, how easy it is for governments and oppositions to attack the judges. As a matter of course, we don't do that in this country, I hope, and I find it more than sad, indeed I'm angry it has happened here. Independence of the judiciary is a fundamental part, of course, of the rule of law. Attacking judges undermines that independence, and all of us should resist the temptation, however irresistible some politicians seem to find it. We should know better. What unites us, my lords, and this is my final point, and what makes this legislation quite hard to understand, is that all of us believe in the importance of pre-sentence reports as playing an important, vital part in sentencing. I practiced criminal law for over 25 years, defending more than prosecuting. In those days, it was inconceivable, this is some time ago, of course, that a first-time offender, or really any offender who might face a first custodial sentence, would not be sentenced without a properly prepared pre-sentence report. And by properly prepared, my lords, I don't mean a 10-minute interview in the cells and then back into court. I mean a well-prepared and thorough report with the probation officer being given the time and the space to do their job. We're all surely shocked to learn that the numbers of pre-sentence reports has fallen by 42% between 2015 and 2023, from 160,000 to 90,000. And I'm afraid one has to ask the question, how many of these reports are having to be prepared much too quickly? I hope we can all agree that pre-sentence reports are an essential part of our system and cannot be allowed to be compromised for financial reasons. That's why the future of the probation service is so vital to this debate, and why, in my view, it would have been better if we could to have waited until the Gork report, the Gork review, and the legislation that follows it.
My Lords, I too would like to begin by paying tribute briefly to the noble and learned Lord, Lord Etherton. He was a mentor, and for 25 years, with his husband Andrew, a close friend. I benefited from his counsel and friendship for many, many years, and I will miss him dearly, like I'm sure many in this house. My spirits were, however, raised by the speech of the noble Baroness Nichols of Selby. I thought her words were really warm, moving, inspiring, and thoughtful. So I'm sure she will make a great contribution to this place. Many of the points I wanted to make about this bill have been made very eloquently by the noble and learned Lord Thomas, and now by Lord Bach. I should say criminal law and criminal procedure, unlike Lord Bach, is not within my field of academic expertise or practice at the bar, but the concerns that I have about this bill are of a more general nature. I do understand and respect the political considerations behind it, but as with other brief and seemingly straightforward pieces of legislation, this bill lacks the necessary clarity. The main problem is, as we heard before, the concept of personal characteristics. The prohibition is by reference to this concept.
The bill does not contain a definition of personal characteristics, but provides a non-exhaustive list of personal characteristics. It leaves open the question of what other characteristics might count as personal characteristics under the bill. At paragraph 14 of the explanatory notes, the effect of the two key subsections of the bill is described as follows. Sentencing guidelines cannot be issued to state that it should generally be necessary to obtain a pre-sentence report based on an offender's membership of a particular demographic cohort rather than the particular circumstances of that individual. The explanatory notes thus suggest that the concept of personal characteristics is related to membership of demographic cohorts. The Sentencing Council's draft guidelines on the imposition of community and custodial sentences, which prompted the adoption of this bill, said that a pre-sentence report would be necessary if the offender belonged to one or more cohorts. The guidelines did not describe the cohorts as demographic because they included characteristics that would not generally be understood as being demographic. It may be that the addition of the adjective demographic in the explanatory notes was designed to give more specificity. But when we then look at the categories of personal characteristics that are specified in clause 1.3 of the bill, unfortunately, it only seems to add confusion. To begin with, we do not see the most obvious characteristic defining a demographic cohort, namely age. Moreover, characteristics that are mentioned in the bill, like belief and cultural background, are not usually understood as characteristics defining membership of demographic cohorts. So I'm not sure the description in the notes of the cohorts as demographic really tells us very much about the meaning of personal characteristics. If we go back to the three personal characteristics that are expressly mentioned, two of them, race and religion or belief, are also protected characteristics under the Equalities Act. But the third one, cultural background, is not. And by the way, cultural background is itself a rather vague notion. I was going to ask the Minister to provide some clarity on the relationship between protected personal characteristics in the bill and protected characteristics under the Equalities Act. And I think the Minister has addressed this issue in part in his introductory remarks, but I'm not sure that what he has said makes the boundaries of the concept of personal characteristics any easier to identify. The bill as currently drafted lends itself to both a broad understanding of personal characteristics and a narrow one. Based on the Minister's introductory remarks, it seems that the government takes the view that the broad interpretation is to be preferred. Can the Minister tell us whether this means that personal characteristics include all protected characteristics under the Equalities Act, as well as other unspecified characteristics? And if so, how do we identify these other characteristics? The explanatory notes also draw a distinction on which others have commented between personal characteristics and personal circumstances. But can the Minister help us understand the dividing line between personal characteristics and personal circumstances? What about education, for example, or socio-economic status? Is that a characteristic or a circumstance? My Lords, there are constructive avenues through which some of these issues can be addressed and the clarity of the bill enhanced. It will be important for us to consider these thoroughly in committee to ensure that the Sentencing Council receives a far clearer legislative instruction than the current draft of the bill provides.
My Lords, what a pleasure it was to listen to the maiden speech of Baroness Nichols of Selby. I'm so glad she took such trouble to explain the complicated background that brought her to this house, so it really adds greatly to our understanding of the way in which she will approach the work that she will undertake here. It was an inspiring speech, and of course she contributed to the merits of this debate as well, which was very valuable. My Lords, as far as the Noble and Lord Etherton is concerned, I can say that I was the last to work with him on his final contribution to the work of the House. He sat as chairman of the Holocaust Memorial Bill Committee. A difficult task because, of course, many members of this House were very concerned about its provisions, and he presided over it with great care and great skill and considerable charm. If he was unwell, and he may well have been, he didn't show it, so I suppose one should say that he conducted his duties as chairman with a great deal of courage. And it was perhaps typical of his kindness that at the very end, as we were approaching Christmas and finishing the work, he did the unusual thing, which I've never encountered before. He, as chairman, sent each member of the committee a Christmas card. And it may seem rather light point to make, but it was very typical of the man. He was very down to earth and very kind and very thoughtful. So we shall miss him very much.
Lords,
as others have said, it would be lovely if we could resolve the dispute which has given rise to this bill without legislation. But we have legislation, and so I'm going to just address what we have before us without speculating as to what might have happened. As we heard particularly from Lord Jackson of Peterborough, there are two issues of principle that arise here. One is the independence of the judiciary, the need to respect that principle, and the second is the principle of equality before the law. As for the first, while the Sentencing Council includes the judiciary amongst its membership and is there to provide guidance to the judiciary, I do not see this as a reason why the bill should not proceed. It does not compromise the independence of the judiciary in the exercise of its judicial function. It does not seek to deal with any decisions delivered in court by members of the judiciary. Its sole concern is with an issue of policy raised by the Council's revised guideline on the imposition of community and custodial sentences. It does not address the passing of the sentence itself. So it is surely right then that the government should ask Parliament to engage with the issues of that kind if it finds itself in disagreement with what the Council has proposed. Our statutes now are full of examples of situations where policy decisions about the nature and length of sentences are made by Parliament. It was not always so. When I began my practice as a lawyer, rather earlier than the noble Lord Bach, 50 years ago, Parliament didn't really say anything about sentencing, and there weren't sentencing councils. It was all a matter for the judiciary. But I think we have discovered that there is a need for balance and also a need for consistency. And that's where the Sentencing Council comes in, and one can understand its function. But I don't think that the fact that this bill is disagreeing with a policy decision by the Council itself in any way undermines or offends against the principle of the independence of the judiciary. It's the application of the principle that everyone should be equal before the law that lies behind the bill. And I can understand the government's concern that the revised guideline does not seem to respect that principle. To say that a PSR is normally to be considered necessary if the offender is from an ethnic minority, a cultural minority, or a faith minority community inevitably raises the question, what about the others? What about the others, the rest of those who are not from those particular backgrounds? As everyone knows, due to years of hollowing out by successive governments, the probation service is short of money. It is under-resourced, and that has given rise to the tragic situation that Lord Bach described so well, the diminution in the number of reports and possibly the quality of the reports themselves that are being delivered. So the problem which we're addressing is while, of course, everybody who is facing a custodial or a community service should have a pre-sentence report, that is not something now that the probation service can deliver for everybody. I do not know myself, because I wasn't party to those discussions, of course, as to why the Council felt it necessary to issue the revised guideline, but it seems likely that it felt that priority should be given to some in a situation where a PSR cannot be got for everyone. And I think I can understand that approach. So I agree with the government. There is a risk that the revised guideline, while sensible in itself and understandable for the reason I've just expressed, will disadvantage those who are not from the particular cohorts that the revised guideline has identified. They face the prospect of being sentenced without a pre-sentence report, and that is a result that in most cases no one would wish to see. But, my Lords, my principal concern, which others have touched on, is with the wording of this bill. This was indeed, as the noble Lord Bach has told us, a point raised at second reading, the second reading of this bill in the House of Commons by Sir Jeremy Wright, the former Attorney General, and he later tabled an amendment, as has been explained, which addressed his point. As he said at second reading, we ought not to address an inequality, one inequality, by replacing it with another. He suggested, and I respectively agree with him, that the phrase personal characteristics in the proposed new subsection 4 to section 120 of the Coroner's and Justice Act 2009 is too broad. As worded, it would seem to prevent the issue of guidelines to deal with cases where information about a particular personal characteristic, and I rephrase that as an individual circumstances, because it might include individual circumstances too in that broad language, is crucial to the just disposal of the case. Take circumstances such as impaired physical or mental health, autism, or some other condition or disability of that kind, pregnancy, or the fact that a person is a primary carer. These are examples of cases which, on its present wording, the wide prohibition that the bill seeks to impose would seek to apply to. So Jeremy's point was that there is a danger of throwing the baby out with the bathwater, and he wondered whether more precise language, the more precise language in the explanatory notes was not used. So I ask the same question. The explanatory notes say that the bill, and I quote, prevent differential treatment. It does this by preventing the creation of a presumption regarding whether a pre-sentence report should be obtained based on an offender's membership of a particular demographic cohort. It's those particular words that he had in mind. The use of the phrase membership of a particular demographic cohort would avoid extending the exclusion too far while addressing more precisely the problem that the government wishes to address. Now, I've rather gathered from what the noble Lord the Minister said in introducing this debate that actually it is the government's intention that the prohibition should extend beyond the list which is given in the subsection, and that is troublesome. But if the government wishes to stick the language that it has chosen for the proposed new subsection, it really should consider rewording the definition in the proposed new subsection 12. What it says is that for the purposes of section 120 of the Act, the 2009 Act, personal characteristics include in particular listed items. The word include, if the Minister will forgive me for saying this, it really is a weasel word. It stretches the point into the unknown, over which the House has no control or opportunity for scrutiny. When a prohibition is legislated for, a prohibition in particular, it should be precise. That would be achieved by replacing the words include in particular with the simple word means, and that would tie the prohibition down to the particular individual circumstances or particular circumstances listed in the subsection. That would give the prohibition a precise meaning while meeting the very particular point in the revised guideline that the government objects to. Now, my Lord, as the noble Baroness Hamwood has mentioned, and indeed the Constitutional Report has drawn attention to, there are reasons to be concerned about the fact that this bill is being fast-tracked. But the fact is that it is being fast-tracked, and I suggest that with it, that brings a reluctance to accepting amendments in this House which would require the bill's return to the other place. If that is going to be the position of the Minister, then I very much regret that, because I hope he will listen very carefully when we reach committee stage to ways in which, without amending the bill or destroying it, we can improve the wording to make it clear exactly what the prohibition is intended to do. The point is that words matter. Words always do matter. And it is the function of this House to address this point, which is why I gave the Minister notice of my point in advance and why I'm addressing the point now, along with others with whom I respectfully agree. So I hope that in order to save time, if that's what the government wants to do, it would look at the wording of these provisions itself and come with an amendment of its own, which meets the objection that I'm raising. But we'll also look forward very much to hearing what the Minister has to say.
My Lords, I want to start by congratulating my noble friend Baroness Nichols on her absolutely brilliant and very moving maiden speech. It's great to be sitting here with her today. Yeah. I also want to thank my noble friend the Minister for his excellent work on this very difficult issue. I believe he was absolutely right to respond as he has. I think this is a question of how we preserve the public's trust in our legal system. As we all know, unfortunately, we generally trust institutions much less nowadays, especially government and politics. Although, that said, the British legal system enjoys a relatively high rating with the public, 62%, versus the OECD average of 54%. This is something we must work very hard to preserve and should feel very proud of. There is rightly some concern that ethnic minorities are overrepresented in the prison system, as the Lamy Review, for instance, found recently. But the majority of the public don't see the sorts of sentencing guidelines that are being discussed today, taking into account religious or ethnic background, as the solution. The polling on this is pretty clear. 72% of the public oppose these moves, and 52% strongly oppose. And this clarity extends across the whole population. There are some differences between gender, age, and so on, but basically that majority view, particularly that strength of feeling, is held across all groups. Essentially, it seems that the public believes that sentencing guidelines of this type risk being unfair and risk disregarding the complexity of causes that need to be taken into account. Now, it might be that the public could and perhaps should know more about how sentences are set, but it certainly seems to me simply saying that they're wrong is not the answer. I therefore agree that introducing sentencing guidelines are more likely to create resentment and risk causing more problems than they solve, and also risk breaking that vital bond of trust between the public and the legal system that matters so much. And I support this bill very strongly.
Yeah. My Lords, I do not regard the decision of the government to try to resolve a difference of view about the contents of the guidelines in bringing legislation before this House as improper or an assault on the Constitution or on the judiciary. But I think it's extremely ill-advised. Ill-advised by the fast-tracking, ill-advised because of the impression it gives about pre-sentencing reports, and ill-advised because the bill is so incoherent. And I want to deal with each of those things. But what it seems to me the government has done is encourage a practice to be deplored amongst governments of finding a political problem and getting out the legislative shotgun and firing the trigger immediately before any serious thought has been given to how a problem can be dealt with properly and effectively. So the bill is both unnecessary and undesirable. Undesirable because it gives the impression that pre-sentence reports are in some way conferring a privilege, whereas they're in fact assisting the judge. If in some cases they lead to someone being given a non-custodial sentence, that may well be because a non-custodial sentence is more likely to reduce reoffending on the part of that person. It assists the judge to make important considerations in sentencing policy, in sentencing practice, which need to be made and increasingly need to be made in a situation where our prisons are desperately overcrowded and their record in reducing reoffending, as the Minister knows all too well, is very weak indeed. But I come to the contents of the bill itself. The bill says that guidelines about pre-sentence reports may not include provisions framed by reference to different personal characteristics of an offender, in particular race, religion or cultural background. In particular implies that other personal characteristics, unspecified, could fall within the prohibition, and the government's explanatory notes on the bill confirm that in paragraph 15, that the list in the bill is non-exhaustive, and that's been further confirmed by various statements ministers have made. So how does the Sentencing Council know if a category or cohort of offenders, other than those named in the bill, is covered by its prohibition? It's a very bad practice to impose, in this case on a single body, the Sentencing Council, a law whose extent they cannot know. There's no known method of deciding what the status in relation to these lawyers of a characteristic which is not specified in it, which does not fall within some generally described category. And we can all be aware of numerous categories to which this applies. Pregnant women, who are already covered, of course, by R versus Thompson 2024. It's not clear to me that if the sentencing guideline included a phrase drawing attention to recent case law on the subject of pregnant women being given custodial sentences, that they would be acting illegally. What is to happen in those circumstances? One can think of a number of others where there is already provision in statute, which the government appears to be saying is unaffected by the bill, but where it's not clear if the Sentencing Council can lawfully draw attention to those features which fall within the personal characteristics. And like the example I took was one that's not named in the bill, but it would apply both to the named characteristics and to the unnamed characteristics. There are many of them. Victims of modern slavery, victims of domestic violence, offenders brought up in local authority care, victims of sexual abuse in childhood, residents of a notorious gang-ridden housing estate characterised by intimidation, children. All of these categories, or nearly all of them, do not fall within those specified in the bill and are obvious features which ought to be in a pre-sentence report. What happens, and I hope the Minister can answer this, if the Sentencing Council draws attention to any of these in any future version of the guidelines which emerges from this process? The bill is a mess. We have a crisis of reoffending. We have a crisis in our prisons. We have a sentencing review led by David Gork. Those are the sort of things we need to be talking about in sentences. There is no crisis in the Sentencing Council. There's a disagreement about the form of words that ought to be used to give guidance to courts on the subject of sentencing. That does not justify fast-tracking of bills, which attenuates the proper debate and discussion and could lead to a situation which Lord Hope described, in which the government expressed reluctance to accept an amendment because the fast-track would be upset a little by the bill going back to the Commons, which is nonsense, really, because that would be done in a day. I hope that his very wise guidance that we should not be deterred from amending the bill by the need for it to go back to the House, that is not what is done. That makes a nonsense of all that we're here to do and the responsibilities that we have. And the Constitution Committee, in the report which is now technically published but not yet widely seen, makes clear its objections to that fast-tracking process. We have all these crises and problems in relation to our prison system and sentencing policy. Here we have a bill which does nothing to address any of them and is an ill-advised move in circumstances which could have been resolved in a much better way.
Yeah. My Lords, it was a pleasure to hear the maiden speech of the noble lady Nichols of Selby, and I particularly liked her comment that politics is about service. And I think that's something that almost everybody in this House understands extremely well and tries to commit to. It's also a pleasure to be in a debate where the lawyers mostly agree. I mean, that is quite unusual because quite often one is debating this or that or whatever, but today it's been rather harmonious. Now, the Sentencing Council is an independent body that saw a problem and tried to do something about it. It has done what it was designed to do, and now the Labour government is running scared of these rather nasty right-wingers who are trying to interfere. I think it was Elon Musk, I mean, perhaps amongst others, who first said that Britain had a two-tier justice system. And he was right. That is exactly what we have. Because some groups are worse treated than others. We do not have equality under the law. We've known about women being less fairly treated for decades, with women being imprisoned for things that men would not be. The Sentencing Council came up with the mildest of changes to address that issue and has been slammed for it. The updated sentencing guidelines don't do anything dramatic. They just ensure the courts have the most comprehensive information about offenders and offences. The revised guidelines put emphasis on the pre-sentence reports in sentencing decisions and offer more clarity on the scope of requirements for community orders and suspended sentences. When the government says that it wants equality under the law, everybody wants that. We all understand that that's something absolutely desirable. But the difference is that I accept the evidence that we currently have a two-tier system of justice where you can end up receiving worse treatment because you're a woman or because of the colour of your skin. And if the government is going to reject the guidance from the Sentencing Council, then what ideas are they putting forward? And I'm only speaking briefly because a lot has been said already, a lot that I agree with, and some I don't, obviously. But I'm just, I don't know, puzzled by the fact that the government doesn't have qualms, or perhaps it does. The Noble Lord Timpson might want to tell us. If the government has qualms about the fact that the Greens, the Lib Dems, crossbenchers, the church are actually speaking against this bill, and what you have is you have the Conservatives supporting you. You have Policy Exchange supporting you. What is that about? Since when did the Labour government want to be supported by this lot? I do not understand where you're coming from. And so please can we remember that we are in a society now that is deeply misogynistic, more than I think any time in my life. Back in the 70s, as a 1970s feminist, I thought we'd won that particular battle. I really thought this was the future for women, that we would be equal in society, and we clearly aren't. And the government ought to address things like that. And I look forward to seeing some of the amendments that are going from more learned people, and I will almost certainly support them.
My Lords, I too want to add my heartfelt congratulations to Baroness Nichols of her wonderful maiden speech. I know you back from North Yorkshire. She was always a wonderful woman, wonderful lady. And if you went in some of her meetings, she was really like a mother hen gathering her chicks around. She was always looking out for somebody who is on the margin, excluded, and tries to draw them in. So what you've heard is what I experienced in reality when you were a politician. And you were still loved in Selby. People still remember you. And I remember the grand opening of the organ in that wonderful, wonderful place. She was there helping tea and coffees and serving and being involved. You did it from the heart. It was never show, but always your smile and your welcome. You knew you come home. So I'm looking forward to hearing what you're going to say. But your maiden speech was one of those things that reminded me of North Yorkshire. Surprise, surprise, some of you may be, but I welcome this bill, actually for the reasons clearly set out in the explanatory notes and the House of Lords Library briefing by Claire Breda. They give the reasons why this is happening. It is happening because the meeting with the Sentencing Council did not want to change things within their guidance. And so the government thought it was right, and the only way you could change it is by legislation. There's no other way because the body is independent. I agree with His Majesty's government that this bill will ensure, and I'd rather use the word equality instead of fairness, for all in our courts. Again, Baroness Hamway was saying exactly the same. So you go for equality, non-fairness, and then everybody is going to be clearly included within it. This law, in the end, will prevent the Sentencing Council from publishing guidelines that stipulate the use of a pre-sentence report, PSR, based on the offender's personal characteristics. They've created this, and I think the government should have been much wiser to pick out those characteristics which really are prohibited to be used as a basis for exclusion from the Humanity Act. And Lord Thomas also said the same thing, that race, religion, and belief are protected characteristics. Why don't you put in those protected characteristics, or simply refer to Section 9 of the Human Rights Act? Because that will be much clearer. And of course, you've done a bit about race, belief, and there is a thing I don't understand. What is cultural background? What does it mean? Does that mean that both of us grew in the same estate? And if you didn't grow in the same estate, you have no background? I mean, what does it mean? And I think that's the bit in the bill I think is not worth retaining. You've got to find something better than that. But I want to turn to that four-letter word, race. As chair of the General Synod's Committee for Minority Ethnic Anglican Concerns, which came out of Faith in the City, we carried out a survey of the way of combating racism in the Diocese of the Church of England in 1991. And we called it Seeds of Hope. And we said this about the nature of humanity. Men and women, boys and girls of every hue and ethnic group belong to the one race, the human race, all made in the image of God, and all are of unique worth in his sight. My lords, the word race has had a troubled history. Racism is born out of ignorance, and sadly, ignorance is not in short supply. And that's why we get this racism. Apartheid in South Africa, for example, believed that color defined the race of a person. And laws were passed from marriage to where you lived and where you were buried, because you belonged to a very different race from those who were governing at the time. Well, next door in Zimbabwe, the seizure of white farms led to the turning of a food basket for the whole region into a basket case. White farmers and their workers belonged to the one human race and deserved to be treated thus far. Humanity belongs to the one human race, even, I want to say, in Zimbabwe. Well, Margaret and I have 3 grandchildren, 2 from a white father and a black mother. The third is from a white mother and a black father. All 3, by the way, are not from mixed parentage or different races. They are blessed to be what we call double ethnic, a white father and a black mother. They are double ethnic. It's not that they are either colored or this or the other stuff. I wish Her Majesty's government had used a better word, which for me is ethnicity and not race. Because that word race has had a very unfortunate history, that most people, when they talk about race, they're talking about me, because I happen to be black, and I happen to be Ugandan. When you are talking about a white person, the word race doesn't appear. Because, I want to say, we all belong to an ethnic group, but also we equally belong to the one human race. And I'm hoping that there will be a way of talking about this so that we bury that word called racism, because it doesn't actually often describe what it is you're wanting to describe. During the Stephen Lawrence inquiry, as we went around, we were in Birmingham, and there were people who had views that every white policeman in the Met is a racist, simply because they happen to be white and happen to be in the police. And it was a very, very difficult gathering. And of course, you then get some black people where you may suggest that their views are racist and they would like to deny that. Me, a black person? Of course they can be racist. Mugabe in South Africa, rather in Zimbabwe. So, would you please listen to the noble and learned Lord Hope? You should bring in an amendment that is easier to understand and describe the very thing you are wanting to do. And to the noble and learned Lord Thomas, he thinks is unnecessary. Yes, if tonight, by miracle, the sentencing council can take out of those words that have made you to create the kind of bill, of course there'll be no need for it, because they won't be in the guidance. But while that still is the case, I would like to support you, please, to make sure that those particular sections which are in the guidance are prevented by law. But may the law please be clearer in what it's doing and drop that question of cultural background, because I don't know what it means, and I'm not so sure whether you know what it means, but it is in the bill.
My Lords, what a lovely maiden speech from the noble Baroness Nichols of Selby. She did Selby and her family proud, and what's better, she talked a lot of grounded sense on this issue, so welcome. My Lords, I actually also welcome this bill, and it really is important, what we're discussing here, that pre-sentencing reports will now not offer differential treatment based on race, religion or cultural background. But as we've heard, it was a close thing. As the noble Lord Jackson of Peterborough outlined, it is important that we note that this is a serious democratic concern, that an unelected Quango, set up by elected politicians, sought to act against the wishes of those same elected politicians. And it's taken urgent, fast-tracked primary legislation to stop it. But I know from the noble Lord Timpson's letter that this broader debate is off limits today, but I'd emphasise that this tension can not be sidestepped moving forwards and needs to be taken on head on. The noble Lord Beath and others say that this bill is unnecessary, but isn't the problem for us that it became necessary because the Independent Sentencing Council flouted democracy, and that should matter. The same minister's letter, by the way, that I referred to earlier, reassures us that this bill will not affect pre-sentencing reports, PSRs in general. That's fine, although it has to be said we do need some attention given to PSRs. Her Majesty Inspectorate of Probation's latest annual report has said that 70% of PSRs are inspected between February 24 and February 2025 were deemed insufficient. And I also think there needs to be more clarity offered to the public about the role of pre-sentencing reports in general, now that we're talking about it in relation to this bill. While there may well be a broad acceptance that in making sentencing decisions, specific individual circumstances of any defendant can be looked at and taken into account, for the public, I think reassurance may be needed that the main focusing of sentencing decisions should be appropriate punishment for particular criminal actions and individual perpetrators' culpability. More broadly, and going back to the specifics of this bill, I commend the Lord Chancellor Shabana Mahmood's clarity about why the original Sentencing Council's revised guidelines offended the principle of fair treatment before the law, and how this seriously did risk eroding confidence in the justice system in general. There is indeed an ever-deepening trust deficit, and I'm not entirely sure that this narrow bill is sufficient in fixing it. Because the reason is that differentiated treatment in criminal justice goes far beyond this sentencing issue. Ms. Mahmood herself seemed to acknowledge that when she stated, and I'll quote her, "As someone who's from an ethnic minority background myself, I do not stand for any differentiated treatment before the law for anyone of any kind. To borrow a phrase from the Prime Minister, she gets it. As Ms Mahmood interestingly also used a key phrase in opposing this differentiated approach when she confronted a two-tier sentencing approach. Now that's a choice turn of phrase, in my opinion. Previously, the popular critique of criminal justice as two-tier that actually really resonated, particularly in relation to the sentencing post last summer's riots, was sneeringly dismissed as a far-right conspiratorial myth by many ministers and politicians. It was written off as some culture wars trope, and we've heard similar slurs here today. And even as recently as April, the Home Affairs Inquiry Committee inquiry into last year's civil disorder described claims of two-tier policing as unsubstantiated and disgraceful. But can I ask the Minister if he acknowledges why there's a widespread perception, reflected in polling and grounded in real-life experience and evidence, that often, even before sentencing occurs, some crimes can be handled differently depending on the race, religion or community membership of the perpetrator? I've just written the foreword for a forthcoming report entitled "The Many Tiers of British Justice When Identity Politics Trumps Impartial Policing" by Hardeep Singh. I will send a copy to the Minister when it's published next month. It's a crucial read. It uses, for example, and explores in detail the loss of confidence in the impartiality of police operational decisions, which increasingly seem to be influenced by the particular community being policed or by broader political concerns rather than criminal justice ones. The plight of the now suspended, now sacked chair of the Met Police Federation, Rick Pryor, indicates this tension. Mr. Pryor was removed from his job after a TV interview in which he discussed how his members' fears of vexatious investigations meant that police officers hesitate before engaging I've lost my place, with minority ethnic Londoners. Referring to some independent office for police conduct investigations, Mr. Pryor reported that some police officers have stopped applying the law fairly to people of all backgrounds. Some noble lords have raised concerns about speeches made today that have raised broad political concerns, and that we should have stuck to the narrow tramlines of this bill, a bit like get back in your lane. Let alone the fact that this is a second reading debate, so we are allowed to stretch broadly. Can I also raise my concerns, which rather mirror those, which is I'm worried that criminal justice is being used in a rather proactive political way, and that they should potentially stick to their lane. Indeed, one thing that this whole Sentencing Council controversy has revealed is the tendency to try and use criminal justice to compensate for perceived racial unfairness and alleged social injustices. The Sentencing Council, in its original statement, admitted this by saying the quiet bit out loud. Quote, "The reasons for including groups for PSRs vary, but include evidence of disparities in sentencing outcomes." Translation, the aim was to go easier on certain groups to address alleged inequalities. The Lord Chancellor in the Minister's letter acknowledged the Sentencing Commission's good intentions in addressing disparities of sentencing outcomes, but I'm not sure whether we should flatter those intentions, because even if the Minister rightly emphasises that these discussions should be done by policymakers, decisions accountable to the public, I have a nagging concern, and maybe the Minister can reassure me as I finish off. The government seem to be accepting at face value the Supreme Court's thesis that racial disparities or inequalities of outcome must mean inequality of treatment and racist discrimination. I fear such conclusions are exactly what leads to inappropriate, proactive, anti-racist correctives and cloud the ability to look dispassionately and objectively at the issue. At the very least, alternative explanations need to be considered. For example, ethnic minorities tend to plead not guilty at a higher rate, leading to less leniency at sentencing. And one hypothesis to explain this is that there's more distrust in advice given by state-provided lawyers, distrust that might legitimately have its roots in the legacy of historic racism. But if criminal justice bodies and politicians push a narrative that the state is institutionally racist, won't that simply deepen and embed such distrust? I think we need actually not to have narrow bills but broader discussions. But in this instance, I hope the narrow bill will clear the way for those broader discussions that should be about the use of the law and the judiciary for political purposes, which I think is worrying.
My Lords, this rather sombre debate has been enhanced by the delightful and endearing maiden speech of the noble Baroness Nichols of Selby. I'm so glad that I was here to hear it. May I endorse the comments made in respect of the death of my learned friend and erstwhile colleague, Lord Etherton. His loss is a personal blow and a blow to this House. My Lords, I believe that it is particularly desirable that judges should have the assistance of a pre-sentence report when sentencing ethnic minority offenders. The Lamy Review identified that ethnic minority, and particularly black offenders, were sentenced to prison more often and for longer than white offenders. The review considered pre-sentence reports and concluded that the role that they played was, I quote, vital, considering the difference in background, both in social class and ethnicity, between the magistrates and judges and many of those offenders who come before them. The problem is that, ideally, provision of pre-sentence reports should be the norm in the case of almost all serious offenders. Singling out the ethnic minority cohort in the guideline is capable of appearing to some to be unfair discrimination. But currently, a struggling probation service appears to lack the resources to produce adequate pre-sentence reports, even in that diminishing number of cases where they are requested. I do not believe that the guideline introduces two-tier justice, nor do I believe that its introduction would severely damage confidence in our criminal justice system. I do not believe that we need this bill, but we are where we are. So let us reluctantly accept this bill, imposing drafting improvements, if we may, and there is scope for those, and move on to addressing the much greater problems that currently beset the sentencing regime.
My Lords, I add my support to the words of the noble and learned Lords, Lord Thomas of Cumgeath, Lord Hope of Craighead, and Lord Phillips of Worth Maltravers, in eloquent tribute to the noble and learned Lord Etherton, who will indeed be greatly missed by not only those in this House who've had the privilege of hearing him over recent years, but also by the wider legal public and the public in general. My Lords, I also join with great pleasure with others in praise of the noble Lady Baroness Nichols' excellent maiden speech, and particularly, if I may say so, the very personal accounts that she included within it. And it was also a great pleasure to hear the noble Lord Sentamu's Yorkshire perspective on the noble lady's contribution to public life. My Lords, turning to the bill, nothing I have heard today has persuaded me that this bill is either necessary or sensible. On these benches, we regard it as an overreaction to a difference, little more than a misunderstanding at the outset, between the Lord Chancellor and the Sentencing Council.
What is more, a misunderstanding that could and should have been sorted out informally by discussion and compromise without resort to emergency legislation, as the noble Lord Bach said. We believe this bill proceeds from a false premise, a fallacy indeed, that the Sentencing Council has produced guidelines that depart from the principle that everyone is equal before the law. In this House, we all believe in equality before the law. The argument for the bill that is advanced is that if PSRs are obtained more readily for particular cohorts of offenders, then those offenders are less likely to go to prison, which the argument goes amounts to two-tier justice. But as my noble friend Lord Beith pointed out, this bill is about the provision of pre-sentence reports, not about sentencing offenders differentially. PSRs are written to assist judges in making the right sentencing decisions. And I suggest that the two-tier justice argument misrepresents what equality before the law means. What it means is the courts treating everyone alike with neither fear nor favour. That's the significance of the saying that justice is blind, and of the iconic statue that tops the Old Bailey. It's about applying the law even-handedly. It does not mean ignoring the evidence, still less skewing the evidence by depriving the court of the ability to do justice on the basis of all the available evidence and information, and so weakening the ability of the courts to dispense justice. The underlying reality, which this bill ignores, is the glaring inequality of outcomes in our criminal justice system, whereby offenders from ethnic minorities have historically been far more harshly treated by sentencing courts and are far more likely to go to prison than their white counterparts, and as Lord Phillips pointed out, for longer. For the evidence of that, one has only to read the well-researched and well-argued 2017 final report of the Lamy Review, mentioned by the noble Lady Baroness Mattinson and by the noble and learned Lord Phillips. Baroness Jones of Molescombe was among many who reinforced this important point, and the bill does nothing to address that reality. Far from it. It ignores three very real truths. The first is that PSRs are the only reliable way that judges can obtain a full and true account of the individual circumstances of offenders that they're called upon to sentence. These reports are a vital source for judges of independently collated information about those individual circumstances, which they need to take into account when deciding between imprisonment and community sentences. They cannot get such information from speeches of mitigation, however well constructed and presented by defence counsel, because those speeches are made on the defendant's instructions and cannot be verified. The second truth is, as the noble Lord the Minister reminded us, that while PSRs ought to be before judges in every case before sentencing, certainly in every case where a prison sentence is possible but not inevitable, yet their availability in practice has substantially declined in recent years. And the reason for that is uncontroversial. Resources for the probation services have been progressively reduced and mismanaged by government over the years. The noble Lord the Minister reminded us that the number of PSRs has reduced by 44% over 10 years. And the third truth is this, that the quality of those reports that have been produced has declined as the time allowed to probation officers to produce individual reports has been reduced, allegedly to save money. My noble friend Baroness Hamway and the noble Lord Bach spoke in some detail of the present weaknesses of many reports, and we thoroughly welcome the government's commitment to increasing resources for the probation service generally and for the provision of more detailed and thorough PSRs in individual cases in particular. So I do agree with the noble Lady Baroness Nichols that we should be making thorough pre-sentence reports available for all offenders, where the options are custody or community sentences, to enable the court to have the fullest material about individual circumstances of offenders when sentencing. Where I part company with the government and Baroness Nichols is that it is neither not logical nor defensible to say, well, if we can't afford reports for all those at risk of prison, we will forbid the judges to prioritise the most vulnerable groups in the interests of an artificial equality. Yet that is what this bill proposes. I agree with the Right Reverend Prelate, the Bishop of Gloucester, that it is plain wrong to forbid prioritising pre-sentence reports in the face of a lack of resources. That is not to uphold equality before the law in the face of a misguided guideline. It is to prevent the Sentencing Council from performing their function in the most helpful way possible in addressing the inequality of outcomes that bedevils the system as it operates at present. It's all very well for the noble Lord the Minister to say that the causes of unequal outcomes are presently unknown, because there is a mass of evidence to the contrary. Even the proposition that doing without PSRs saves money is deeply flawed. If, following the logic of the two-tier justice argument, more PSRs lead to fewer custodial sentences, then PSRs do not increase public costs. They save the public money. No one denies that prison is far more expensive than community sentences. That's true on all the evidence, even leaving out of account the knock-on effects of imprisonment on prisoners' families, housing, employment, and dependence on the state, and the effects of all that on the public finances. Then there's the clear evidence that community sentences are far more effective than prison at reducing reoffending. And reoffending costs the public purse, on the average estimate, about £18 billion a year. If PSRs are more widely available, then that may contribute to a reduction in reoffending and so a saving of resources. My Lords, the bill raises two constitutional issues. The Constitutional Committee has considered this bill and has prepared a report which has technically been published today, but of course no one's had time to read or consider the report. And the rush is relevant to the first constitutional issue, which is an issue on which the committee criticised this bill, and that is the use of fast-track emergency legislation once any emergency has passed. As we know, the Sentencing Council paused implementation of the guidelines specifically to give us time to take a view, to give this Parliament time to take a view. This bill has no place in being treated as emergency legislation. It's been rushed at every stage, and the rules about time lapse between stages are designed to allow for reflection and consultation between stages, not just in Parliament, but outside as well. And this bill has suffered from a lack of both. The second constitutional issue is this. While, of course, I accept the point that Parliament has the power to legislate and the right to legislate, to alter the powers or functions of the Sentencing Council. Nevertheless, the Sentencing Council is itself a creature of statute, and that power ought to be exercised with great caution. It was established by the Coroners and Justice Act as an independent body to give advice to judges, its purpose being to assist judges in the conduct of their sentencing decisions and to help them to achieve the appropriate level of consistency in sentencing approaches and outcomes. That is a judicial function. It's not sensible for the executive to interfere. Parliament sets out maximum sentences and sets out a set of rules. But it is dangerous for the executive to interfere through introducing an Act of Parliament with the way that the sentencing guidelines are then produced, and to set out what they should and should not contain. That runs the risk of an unwarranted and unhelpful interference by the executive in the working of the judiciary. In the House of Commons, Robert Jenrick, the Conservative Justice spokesperson, proposed an amendment proposing what was in effect a veto over sentencing guidelines produced by the Sentencing Council. In this House, the noble Lord Jackson proposed much the same thing. That is inappropriate. My Lords, in addition, the bill is incoherent in its drafting, what the Constitutional Committee politely calls legislative uncertainty. I don't wish to go into detail because the points made throughout the House by my noble friend Baroness Hamway, by the noble and learned Lord Thomas of Cumgeath, by the Right Reverend Prelate, the Bishop of Gloucester, Lord Bach, Lord Verdebrame, and the noble and learned Lord Hope, all on personal characteristics. They're surely right. Are not pregnancy, being transgender, sexual orientation, all personal characteristics? There are also circumstances that a sentencing court might want to take into account, as well as ethnicity, particularly where those characteristics give rise to persecution, abuse, and psychological and mental health issues. Those are just the kind of factors that might be considered and explained in PSRs. Why should sentencing guidelines not indicate that some of these characteristics are important and make a PSR more valuable to judges? For my part, I find any distinction between personal characteristics and personal circumstances ill-defined and unhelpful. And I agree with the noble and learned Lord Hope and my noble friend Lord Beef that the wording of the prohibition is profoundly unhelpful. My Lords, I shall not take up the invitation of my noble friend Baroness Hamway to foreshadow at second reading amendments that might later be considered. We've heard a number of suggestions for committee stage. I would also consider the insertion of the words "without good cause" into the prohibition to allow for some assessment of what may or may not be sensible. But my Lords, that's for the next stage of these proceedings, so I shall leave it there.
My Lords, I hope the House will permit me to begin with a word about the noble and learned Lord Etherton. He was, as the noble and learned Lord Thomas of Cumgeath remarked, a very great man. Outside this House, he was a brilliant chancery lawyer and a wise judge. And in this House, he was a wonderful person to have on your side. And I remember, as a minister, an intimidating, if always courteous, opponent to have on the other side of a debate. I will miss him. May his memory be a blessing. My Lord, this bill has been introduced to remedy a problem, and it does, more or less, remedy that problem. But the bill could, and we say should, be doing more, because the immediate problem which led to this bill has shone a light on a deeper issue and one of constitutional significance within the criminal justice system. And on that point, I agree with the noble lady Baroness Hamway, although we differ on the substance of the bill and what has led to it. Now, not surprisingly, given the number of former senior judges from whom we've heard this afternoon, we've heard many excellent speeches. More surprisingly, given the number of lawyers who've spoken, we've kept more or less to time. But may I immediately single out a non-lawyer, indeed the moving maiden speech of the noble lady Baroness Nichols of Selby, which it was a real privilege to listen to. I knew that you could get almost anything at Woolworths. I didn't appreciate that you could get future baronesses as well. I look forward to hearing more from the noble lady in our work in this House in the coming months and years. Now, as we know, the Sentencing Council, an unelected body, which has 8 members appointed by the Lord, now Lady Chief Justice, and 6 members appointed by the Lord Chancellor, introduced proposed sentencing guidance that could have led to a divisive criminal justice system, one that risked dividing people by race, religion and identity. That point it appears, at least, is not now in dispute, at least between the two front benchers, given that first the Shadow Lord Chancellor and then the Lord Chancellor herself publicly opposed the proposed guidelines. Originally due to come into effect from the 1st of April this year, the proposed guidelines said that, quote, "It will normally be considered necessary for judges and magistrates to request a pre-sentence report for certain cohorts of individuals. Those cohorts included if the defendant belonged to, and I quote, an ethnic minority, a cultural minority, or a faith minority community." Now, I should say at the outset that I too am not entirely sure what is meant in these terms by a cultural minority, if it is not already an ethnic minority or a faith minority. Are we talking about Morris dancers or devotees of Wagner's Ring Cycle? As the bill uses the same term, this isn't really a joke. If the government wants to put this phrase into legislation, it does have to tell us what it means. And I look forward to the Minister, to whom I've also given notice of this and other points, giving a few examples, I hope, of a relevant cultural minority in this context. Now, what was the effect of these guidelines? It was quite simply that if you were in one of these groups, then a pre-sentence report would normally be considered necessary. And what's the effect of that? It means that your chances of receiving a non-custodial sentence have increased. Pre-sentence reports, typically written by a probation officer, are key to judges and magistrates deciding whether to sentence an offender to prison or to a non-custodial community order, particularly in borderline cases. As a result, deciding which defendants are included in the cohorts where a pre-sentence report will normally be required and which are not, can be key in deciding who goes to prison and who doesn't. Now, as a matter of statute, courts have to follow these guidelines from the Sentencing Council. They are not optional. Prior to 2009, courts in England and Wales were directed that in sentencing they, quote, must have regard to any guidelines which are relevant to the offender's case. That was section 172(1) of the Criminal Justice Act 2003. During the passage of the Coroners and Justice Act 2009, the provisions concerning sentences attracted considerable debate, and the previous requirement for courts merely to have regard to any guidelines was replaced in clause 125, with courts being required to follow any sentencing guidelines which are relevant, unless contrary to the interests of justice. And that was replicated in section 59 of the Sentencing Act 2000. Now, I should therefore now deal with some of the points made by, on behalf of, and actually by as well, the Sentencing Council. And for the avoidance of any doubt, while this ought not to be necessary to say, let me say that I firmly believe in the independence of the judiciary. Indeed, I believe that we have the finest judiciary in the world. But that does not mean, my lords, that one cannot respectfully respond to points which have been made publicly on behalf of the Sentencing Council to the Lord Chancellor. So when the chair of the Council, Lord Justice Davis, wrote to the Lord Chancellor on the 10th of March this year, he made the point that it is still possible for a judge or magistrate to order a pre-sentence report if they're sentencing an individual not captured within one of these demographic groups. Now, that is, of course, absolutely true. But with respect to Lord Justice Davis, it rather misses the point. It is the almost automatic nature of the pre-sentence reports for certain groups, and it's the discretionary nature for other groups, which is the issue at heart. Similarly, in his later letter, dated the 27th of March, what the learned Lord Justice termed the crucial point was that a pre-sentence report will provide information to the judge or magistrate, but it will not determine the sentence, a point made a few moments ago by the noble Lord Marks of Henley. Now, again, that's true. But again, with respect to the learned Lord Justice, while a pre-sentence report does not mean that you will get a non-custodial sentence, it's certainly harder to get a non-custodial sentence without one. And so, to put it very bluntly, if the noble Lord the Minister and I were each charged with the same offence in the same court with the same previous criminal record, these guidelines would have meant that I would almost certainly get a pre-sentence report and he might or might not. And that would mean that my chances of a non-custodial sentence were better than his, simply because I am a member of a minority faith community, and that, I suggest, is entirely unjustifiable. And it is no answer to that point, I suggest, to say that there are disparities in sentencing in our criminal justice system for certain groups. There are those disparities, and we need to understand why they exist and work to eradicate them. But these guidelines are not and never were the answer to that problem for three reasons. And I should say, like my noble friend Lord Jackson of Peterborough, I should add that I'm also indebted to Policy Exchange's paper by David Spencer, and may I say especially to the person who contributed research support for that paper. First, the guidelines did not target only those groups where we see disparities. Black defendants, for example, do appear to receive longer sentences for the same offence than do white defendants. But do Jewish defendants receive longer sentences? To take an example of a minority faith community, I've seen no evidence of that, and it doesn't appear that the Sentencing Council did either. These guidelines were therefore not properly targeted at what they said was the problem. Second, as the Minister reminded us, the reasons why black defendants receive longer sentences, indeed to use the words of Lord Justice Davis from his own letter, remain unclear. What is clear is that those reasons are complex, as the noble lady Baroness Mattinson reminded us, and do not, or certainly do not necessarily, involve bias on the part of sentencers. Now, I'm sure that many noble lords like me are devotees of the legal podcast Double Jeopardy, hosted by the noble Lord MacDonald of River Glaven, the former Director of Public Prosecutions, who, alas, is not in his place. But as I see that the noble and learned Lord Falconer of Thoroton is also not in his place, I feel sufficiently charitable to say that his legal podcast, Law and Disorder, is also very good, and sufficiently brave to add that it's almost as good as Lord MacDonald's. Now, what Lord MacDonald did do in his podcast recently, and the noble lady Baroness Fox of Buckley touched on this, was to point out that black defendants plead not guilty in a higher proportion than do white defendants. And of course, sentences are higher if you're found guilty after a not guilty plea, because you lose the guilty plea discount. Black defendants, he pointed out, also elect for Crown Court trial proportionately more than do white defendants. The sentences are generally higher after conviction in the Crown Court than the Magistrates' Court. Now, I'm not suggesting that these 2 points explain the entirety of the disparity. In fact, I'm sure that they do not. There are likely, therefore, to be a number of reasons for the disparity, which, I repeat, we should work to eradicate. And on that point, I do agree. This is a sentence I rarely utter. I do agree with the noble lady Baroness Jones of Moulscombe. But to get back in my normal furrow, where I disagree with the noble lady, is this. You don't work to eradicate disparities by introducing additional and different discrimination into the system to somehow correct for those disparities, because there is one fundamental principle at the heart of our justice system, and it's this: equality before the law. Now, I'm fond of the Minister, as he knows, and so I don't propose to give him too hard a time in having to defend his boss, the Lord Chancellor. But the plain fact of the matter is that despite having a representative on the Council when the guidelines were discussed, the Lord Chancellor only acted once alerted to the problem by the Shadow Lord Chancellor. Now, the Lord Chancellor said that she was not personally aware of the guidelines until Mr. Jenrick's statements brought them to her attention, and of course I entirely accept that. But given the seniority of some of the officials attending those meetings, the guidelines should have had warning bells ringing and lights flashing in petty France. That they didn't realise that these guidelines wouldn't be acceptable to ministers would indicate that there might be something of a problem of groupthink. But to be fair to the Lord Chancellor, once she was alerted to it, she did get to grips with the issue, including by way, as I'm sure noble lords have seen, by way of a polite but sometimes feisty correspondence with Lord Justice Davis, and this bill is the result. The real issue, however, is the relationship between the Sentencing Council and the government, and between the Sentencing Council and this Parliament. And I do want to take a few minutes on this topic because it's fundamentally important and often misunderstood. And while I listen carefully to the noble and learned Lord Thomas, as I always do, this is second reading and not committee. And therefore I do want to take a moment to touch on this. Because, and this is an important point, to say as many do, sentencing is a matter for judges and judges alone is too simplistic, and if meant literally, it's also wrong. Individual sentencing, i.e. the sentence handed out in a particular case, is rightly a matter for and only for trial judges and magistrates. The government must not be involved in that. But the setting of overarching sentencing policy is very clearly a matter for government and Parliament. And so here I must again disagree, and again with respect, with Lord Justice Davis, the chair of the Sentencing Council. In his 10th of March letter to the Lord Chancellor, he said this, and I quote, "There's a general acceptance of the guidelines by the judiciary because they emanate from an independent body on which judicial members are in the majority. The Council preserves a critical constitutional position of the independent judiciary in relation to sentencing. In criminal proceedings where the offender is the subject of prosecution by the state should not determine the sentence imposed on an individual offender. If sentencing guidelines of whatever kind were to be dictated in any way by ministers of the Crown, this principle would be breached." I respectfully disagree with Lord Justice Davis for three reasons. First, as I've said, we need to distinguish between the sentence imposed on an individual offender and the wholesale policy environment in which sentencing frameworks are set. The former is for the judiciary and for the judiciary alone. The latter is not. Parliament, and therefore ministers and government, must have a critical role in setting overarching sentencing policy and frameworks. This bill, for example, is entirely proper constitutionally. Indeed, for many decades, we didn't have a sentencing council at all. It's a creature of fairly recent statute. Parliament obviously has an important role in setting sentencing policy. The upper limits for the sentencing of offenders are set by Parliament through statute, for example in the Theft Act 1968. And in addition to setting maximum limits, Parliament sometimes set minimum limits for offences as well, although courts can often depart from that if exceptional circumstances exist. And it is important that Parliament holds the pen, because ultimately Parliament is accountable to the electorate. The public bear the impact of crime, and it's government ministers who are responsible for allocating public funds to the criminal justice system of courts, prisons, probation officers, police and lawyers. And those lawyers. And those ministers are ultimately accountable to Parliament and the electorate. Indeed, it was striking that Lord Justice Davis took the view in his letter, and this point has been made by some contributions today, that the inclusion of these specific cohorts in the proposed guidelines was not, and I quote, a policy decision of any significance. The fact that both the Shadow Lord Chancellor and the Lord Chancellor immediately took a different view to that of the Sentencing Council, and that we now have this bill before us, might indicate that it was in fact a policy decision of real significance, and that government and Parliament are entitled to have a role in such policy decisions. And so I respectfully agree with much of the speech of the noble and learned Lord Hope of Craighead. Second, Lord Justice Davis's letter implied that the judiciary only accept and follow sentencing guidelines, quotes, because they emanate from an independent body on which judicial members are in the majority, close quotes. That, with respect, cannot be right. Judges follow the guidelines because they are part of a legally mandated framework set out in statute, ultimately derived from Parliament. And my point is that so long as any body is properly constituted under an Act of Parliament, of course our judiciary would follow it. Third, and this point has been made earlier, the distinction which Lord Justice Davis draws between courts and what he calls the state is, I suggest, somewhat elusive. Courts are part of the state, as the Courts and Tribunal Judiciary's own website makes clear. I assume when he referred to the state, he actually meant the executive or the government. And I agree with him respectfully that the government should not be involved in sentencing individual offenders. but the executive and this Parliament should be involved in the sentencing framework and in sentencing policy. And to that end, I do invite the Minister to let us know whether, as part of its thinking about the Sentencing Council, the Government is again considering a proposal not taken up by the majority of the working group which led to the establishment of the Sentencing Council, that sentencing guidelines from the Sentencing Council, before they are implemented, should be subject to approval by Parliament. Would you also tell us if the Government is considering whether the House of Commons Justice Select Committee, which at the moment is a statutory consultee of proposed guidelines after they've been formulated, might itself have a representative on the Council itself? These are constitutional matters. I respectfully disagree with the noble Lord Marks of Henley as to the answer to them, but I think we do agree that these raise fundamental constitutional points. And for those reasons, I look forward to working on this short but important bill as it passes through the House. I'm very grateful to the Minister for his engagement to date. No doubt the House in all of its quarters will debate in its usual way and seek to improve this bill in its future stages.
I would like to start my closing speech, my Lords, by paying tribute to the noble and learned Lord Etherton. Being relatively new to this place, I never got to know him, but it's clear how much he was deeply respected and admired. And he's been described as a kind person, and that is something that I hope one day would be my epitaph. My Lords, I thank noble Lords for their values and contributions over the course of the debate today. The depth of knowledge and experience in this House has certainly been on full display. It has also been a pleasure to be in this place for my noble friend, the Baroness Nichols of Selby's maiden speech. I warmly welcome her to this place and look forward to working with her in the years to come. You clearly have a lot to contribute. Yeah. Thank you to the noble Lords who have raised perceptive questions over the course of today's debate, and to those who have spoken to me privately. I hope that they will feel I have addressed their points in my closing remarks, and if I do not cover them now, I will follow up in writing to address their points. As the noble and learned Lord Hope said, words matter. I hope that my closing words matter and are helpful to answer noble Lord's questions. As I set out in my opening speech, the Sentencing Council's revised imposition guideline risks differential treatment before the law. And as we've discussed, this bill is not about the wider role and powers of the Sentencing Council. It is not about restricting the use of pre-sentence reports. In fact, this government is committed to increasing the use of pre-sentence reports. Rather, it is about the very specific issue of the Sentencing Council issuing guidelines on pre-sentence reports with reference to an offender's personal characteristics, rather than all the relevant facts and circumstances of the case. A number of noble lords, including the noble and learned Lord Phillips, Baroness Hamwee, Right Reverend Prelate the Bishop of Gloucester, and Lord Bach, have asked why this bill is necessary and whether it was possible to resolve the matter with the Sentencing Council without primary legislation. In response, I would explain that we first exhausted all other options prior to introducing this legislation. The imposition guideline was due to come into effect on the 1st of April this year. Ahead of this, the Lord Chancellor used her existing power to ask the Sentencing Council to reconsider. Unfortunately, the Sentencing Council declined to revise the draft guideline. It was right at that point to act quickly to introduce the legislation. As a result, the Sentencing Council decided to put the guidelines on pause, while Parliament rightly has its say, and we're grateful to them for doing so. By acting quickly, we prevented a guideline coming into effect which risked differential treatment before the law. This legislation has been necessary to achieve this and to clarify this government's commitment to equality before the law. My noble lords, including Lord Beath, have questioned the scheduling of this bill. I'd like to reassure my noble lords that the dates for committee and report have been agreed in the usual channels in the usual way. Noble Lords, Lord Jackson of Peterborough, the Right Reverend Prelate Bishop of Gloucester, Baroness Fox and Baroness Mattinson have spoken about the importance of trust and consistency in the justice system. As the speed with which we introduce the bill demonstrates, this government is definitive on its stance with regards to equality before the law. The issues that have been raised with regards to disproportionality in our justice system are the domain of government, politics and Parliament. This bill serves to reassert our ability to determine this country's policy on the issue of equality of treatment before the law. As my noble friend Baronet Mattison set out, we must work to preserve trust in our excellent legal system, and I thank her for sharing her considered views on this. It is, of course, so essential to victims that they are able to trust in our legal system and know that everyone will be treated equally before the law. Implementing a sentencing guideline which could lead to differential treatment before the law puts trust in the legal system at risk, which is why we acted quickly to address this. To address the question from the noble Lord, Lord Jackson and Lord Wolfson about what this bill means for the future of the Sentencing Council, I would reiterate that the Sentencing Council has done valuable work bringing consistency to judicial decision-making. But developments on the imposition guideline have clearly revealed a potential issue, where the Council is dictating policy that is not this government's and does not express the will of Parliament. The Lord Chancellor is therefore reviewing the powers and function of the Sentencing Council. It would not be appropriate to deal with that wider issue through fast-track legislation, given the significant policy and constitutional issues involved, and it is right to take the time to consider more fundamental reform like this. The Lord Chancellor will be considering all options. I know that many in our Lordship's House will have valuable experience to contribute. Baroness Hamway and other noble lords asked how this bill interacts with the review of sentencing being led by David Gauke and ably supported by the noble and learned Lord Burnett. I would like to reassure my lords that this bill will not have any impact. This bill is addressing the specific matter at hand regarding the Sentencing Council guidelines. The sentencing review is a wider review of sentencing, and we look forward to considering their recommendations in due course. Turning now to the questions raised over the detail of the bill, which the noble and learned Lord Thomas, the noble and learned Lord Hope, Lord Verderami, Lord Bach, Lord Beath, Lord Centimanu, and Lord Wolfson have raised. What is clear from this debate is the government's objective is to help ensure equality before the law. We are clear that an offender should be judged by a court on an individual basis according to the particular facts and circumstances of their case. It is not for the Sentencing Council to set in guidance that judgment should be made on the basis of personal characteristics like race or ethnicity. The government has used the broad term personal characteristics to make it clear that any reference to preferential treatment for particular cohorts is unacceptable. The bill states that personal characteristics include race, religion or belief, or cultural background. But these are examples, not a comprehensive list. Personal characteristics is also intended to include a wide range of characteristics, for example, sex, gender identity, physical disabilities, and pregnancy status. This is broader than the concept of protected characteristics in the Equality Act, which is a closed list and is not wide enough, for example, to address the reference in the guideline to being a member of a cultural minority. After careful consideration, the government has therefore concluded that the most appropriate and principled way to respond to the issues raised by the guideline is to use the broader concept of personal characteristics in the bill. The term demographic cohort is used in the bill's explanatory notes. However, the use of demographic cohort was not intended to, and I believe does not, narrow the definition of personal characteristics. A demographic cohort is a way of describing people who share certain personal characteristics. It is used in the explanatory notes to provide additional context to the bill, but it would not be an appropriate alternative to the current drafting and would, in my view, raise further difficult questions of definition regarding what amounts to a demographic cohort. Personal characteristics is a term used and understood in other contexts, and the government considers it is the best formulation to address the issues raised by the guideline. The noble Lord Bach raised concern over whether this bill interferes with judicial independence. To be clear, this bill does not in any way influence individual sentencing decisions. Individual sentencing decisions clearly remain a matter for the independent judiciary. As I've said previously, however, the issue of tackling disproportionate outcomes within the criminal justice system is a policy matter and should be addressed by government ministers. The narrow change introduced by the bill targets aspects of the sentencing guidelines which relate to equality of inputs, We're therefore addressing a policy matter and are not encroaching on judicial independence. It is regrettable that some of the recent debates have strayed into comments about individual judges and their decision-making. And I know Lord Berk will be reassured that this government will always support judges to do their jobs independently, and I know the Lord Chancellor takes her duty to defend judicial independence very seriously. And as a number of noble and learned lords have said today, we are very lucky to have a world-class and highly regarded judiciary. The noble Baroness Hamway, the Right Reverend Prelate, the Bishop of Gloucester, Lord Marks, Baroness Fox, and the noble Baroness Nichols of Selby have rightly raised concerns about probation capacity, which is something I think about in my role on a daily basis. One knock-on effect of this is the consistency and quality of pre-sentence reports. This government supports the wider use and improvement of pre-sentence reports within our courts, and I agree with the noble Lord Jackson that they can be valuable in all cases for all defendants, regardless of their membership of a certain cohort, and should be obtained unless a judge believes that they are unnecessary. We are committed to ensuring that pre-sentence reports are available when needed. The noble Lady Baroness Hamway asked what will happen to pre-sentence reports which were being prepared when the bill came into effect. I can reassure her that there will be no impact on pre-sentence reports in the process of being prepared. This bill is not about the ability of a court to request a pre-sentence report. The test remains that under Section 30 of the Sentencing Code, that a PSR should be requested unless it is considered unnecessary. This is about council guidelines and the need to protect the principle of equal treatment before the law. We have publicly outlined the steps we're taking to increase capacity in the probation service, enabling it to undertake more valuable work such as this. Next year, we will bring 1,300 additional new trainee probation officers on board. And but as noble lords are well aware, and I've spoken to a number of noble lords privately about this matter, it takes time to train and induct new staff and to allow them to become the brilliant probation officers we so highly value. I have a lot to do to help our fantastic probation staff achieve what we know is possible in the service. To support our probation staff, we are embracing technology, including AI. Work is ongoing that is improving the flow of information, so critical to an accurate assessment of an offender's risk. And new tools are beginning to strip away a probation officer's administrative burden. There is much more work still to do. However, given the challenges faced by the probation service, new staff and better processes are not sufficient on their own. Faced by a caseload of just over 250,000 offenders, we need to think about how we use the probation service more effectively. And the theme of the debate, and highlighted by Lord Marks, has been on tackling disproportionality across the criminal justice system. We know that more must be done to address inequalities, and we're committed to tackling racial disparities, as I'm sure Baroness Jones will be pleased to hear. As the Lord Chancellor set out in the other place, and the noble Lord Wolfson has questioned, she's commissioned a review into the data held by the Ministry of Justice on disparities, and we will carefully be considering next steps. We're also taking action to increase diversity in our staff, and are working with the judiciary to make sure that our appointments are reflective of the society we serve. This has included supporting underrepresented groups to join the judiciary. Particular concern has been raised by the noble Baroness Jones about how this bill may impact upon women, and in particular pregnant women. As the chair of the Women's Justice Board, I've paid particularly close attention to this matter and have also spoken with board members. To be clear, nothing in this bill prevents judges from requesting pre-sentence reports for pregnant women, nor will it affect Court of Appeal case law, which states a pre-sentence report is desirable in the case of pregnant or postnatal women. Judges, therefore, will continue to be able to request pre-sentence reports in cases where they ordinarily would, including, for example, appropriate cases involving pregnant women, and we would expect this to continue. We are committed to achieving equal outcomes for women. In conclusion, this is a targeted and specific bill which serves to protect the important principles of equality before the law. I thank all noble lords who have taken part in this debate, and I look forward to engaging with them as the bill progresses. I beg to move.
Actually moves the second reading. He said told the House that the term personal characteristics is used in a number of contexts in justifying why it's used here. I don't expect him to answer this in detail now, but could he write to the House to explain what those contexts are so that we have them in our minds as well?
I will very happily write. As noble lords are aware, I'm not an expert on the finer details of the law, so that would actually help myself as well. I beg to move.
The question is that this bill be now read a second time. As many as are of that opinion will say content. Content. The contrary not content. The contents have it.
My lords, I beg to move that this bill be committed to a grand committee.
The question is that this bill be committed to a grand committee. As many as are of that opinion will say content. Content. The contrary not content. The contents have it. My lords, I'll just pause for a moment while those noble lords who may wish to, once I've sat down, can leave the chamber. Question on a statement made in the House of Commons yesterday on Middle East update.
My Lords, the Middle East continues to face a wide range of challenges, as was made clear in the debate in the other place yesterday afternoon. Fighting and instability continues in many parts of the region, and state actors in the Middle East pose an increasing threat to the UK on the domestic stage. Let me start with Syria. As noble lords will be aware, representatives from several groups in Syria convened a national dialogue conference in March this year to discuss a new national constitution. Whilst there was agreement on a commitment to human rights and transitional justice, several groups from the Kurdish and Druze communities attacked the al-Sharia government for what it claimed was a lack of representation. Kurdish groups have since claimed that they have secured agreement on a federal system of government, although this has neither been confirmed nor publicly announced by the incumbent government. So I wonder if the noble Lord the Minister could please update the House on what the government's assessment is of the involvement of Kurdish groups in the constitutional making process in Syria, and is the government concerned that a lack of clarity in these discussions threatens the process? My Lords, whilst we celebrate, as I'm sure the whole House does, the fall of Bashar al-Assad, we cannot lose sight of how important the next steps are in Syria. The way in which the Syrian state is reconstituted is of vital importance to ensuring that a lasting peace can be maintained. The international community must do all that it can to ensure that these debates are settled by negotiation and by compromise, and not through further violence. Syria is a fundamentally important player in the region, and it is vitally important for the sake of the wider international community that one destabilising government is not replaced by yet another one. May I therefore ask the noble Lord the Minister what discussions or support the government is providing to Syrian authorities on how they can take proactive, balanced steps in the reconstruction process, and what discussions are the government having with other global partners such as the US on how the process in Syria can be supported. My Lords, noble Lords will have heard in the Home Office statement made in the other place yesterday that British counter-terrorism police arrested several Iranian nationals on suspicion of intent to perform a terrorist act. The details that we have make it clear that security services are investigating a state-level threat from Iran. My noble friend Lord Davis of Gower covered this in his earlier remarks, but the matter needs reiterating. Iran poses a very real, very direct threat to the UK domestically, as well as to the wider Middle East. It has recently backed an attack on Ben Gurion Airport, Israel's main international hub, and continues to support destabilising organisations across the entire Middle East. Iran continues to pose a great threat to the security of Israel and to its allies. Iranian authorities this week claim to have created a new missile with a range of 1,200 kilometres and have warned that American military bases across the Middle East fall within its scope. Given the scale of the threat that Iran poses to us in the UK and to our ally in Israel and to the US, does the Noble Lord the Minister recognise that our continued support for Israel's right to defend itself against such violence is even more essential? Can the Noble Lord the Minister also update the House on what steps the government is taking to continue to undermine Iran's malign influence in the Middle East? Iran continues to destabilise, threaten and attack partners across the region, and its foreign and military policies are some of the most fundamental barriers to any efforts to gain peace in the Middle East. It is vitally important that the government addresses the threat of Iran robustly, both for our own security and that of our partners on the world stage. Finally, my lords, I want to turn to Israel. We must remember that 59 innocent hostages continue to be held in cruel captivity by Hamas, and those who are still alive have no access to aid or communication with their families. These hostages have now been imprisoned for nearly 600 days. We can never forget that it was the kidnapping of these innocent people by Hamas and the attacks which contributed to the conflict that we see today. I therefore want to ask the Noble Lord the Minister what discussions have the government had with partners in the US and Europe on how those remaining hostages can be freed and returned to their families. We are clear that Hamas, the terrorist organisation who have acted tirelessly to inflict pain, misery and suffering on communities in Israel and Gaza, cannot continue to remain in power. They have to be eradicated from the region if we are ever to see a lasting peace. Could the Noble Lord the Minister please confirm whether the government has a clear strategy on removing Hamas in Gaza? In conclusion, my lords, the UK should support all efforts to secure peace, security and stability, which means standing up for our allies and our values in proactive engagements with partners across the Middle East. The government has a duty to continue this work, and I hope the Minister will be able to address these many points in his response.
I'm addressing the statement that was made in the Commons and has just been, in effect, repeated in the Lords, which was where the Minister in the Commons addressed the announcement made by the Israeli Prime Minister that the Israel Security Cabinet, I'm quoting here, has approved a plan to expand and intensify Israel's military operations in Gaza. And that will be my focus because that was the focus of the statement. The government has pointed out that Hamas will not be defeated by military means and has expressed, and I quote, outrage at actions of the Israeli government. Israel has violated the deal with Hamas by imposing a siege and refusing to start phase 2 of the deal. That siege has lasted 65 days. UNRWA says that nearly 3,000 aid trucks have been prevented from entering Gaza. The World Food Programme has announced that its food stocks in Gaza have been completely depleted, and the statement makes reference to these points. Does the Minister agree that Israel imposing a siege on Gaza and preventing humanitarian aid coming in constitutes collective punishment of a civilian population, which is illegal under international law? Israel's finance minister has now said that Gaza will be, and I quote, totally destroyed. Does the Noble Lord the Minister condemn that statement? The government, in its statements, says that 52,000 people have already been killed, and others have estimated that it's higher. Around 90% of the population of Gaza has been displaced at least once. Many have been displaced multiple times. Israel says that it plans to take over the distribution of humanitarian aid to Gaza at hubs controlled by their military. The UN has criticised this as a violation of global humanitarian principles, and its agencies will not participate. What action will the government take here? 105 hostages taken in violation of international law in appalling violence were released in November 2023 and 33 during the latest deal period. That is why the Israeli hostage families argue that negotiations have had a far greater success in securing the release of hostages than military action. And it is welcome that the government says that Hamas will not be defeated by military means. That is surely right. Following President Trump's repeated comments, will the minister confirm that Gaza is for the Palestinians, that it must be rebuilt and liberated for the Palestinians? What actions is the government taking to ensure that Israel adheres to international humanitarian law in Gaza and immediately ceases indiscriminate attacks on civilians, protected workers such as aid workers and journalists, and protected infrastructure such as schools and hospitals? It is essential that we ensure that no UK weapons can be used to perpetrate human rights abuses in Gaza. With the resumption of Israeli strikes on Gaza, does the minister agree that the UK must now move urgently to suspend all arms sales to Israel? Israel is continuing its military invasion of West Bank cities. This included tanks in the city of Jenin for the first time in 20 years. According to the UN, it has displaced 40,000 Palestinians, who, according to the Israeli defense minister, will not be allowed to return for at least a year. The US, the UK, and other European governments have condemned the continued expansion of illegal settlements, but over 250 illegal settlements have been built across the West Bank, now with over 700,000 settlers. Given Israel's refusal to withdraw its illegal settlements, in line with the advisory opinion of the International Court of Justice, when will the government take action to stop the continuation of these violations of international law? And can the minister explain how massive Israeli settlement expansion is in any way aligned with the government's stated goal of a two-state solution? The noble Lord the Minister will know that his colleague in the other place, although condemning what was happening, found that MPs were not satisfied with the level of action the government was taking. Across the House, that concern was expressed. Therefore, can I ask him, does he not agree that the government must now join almost 150 other states in recognising a Palestinian state? Surely some hope should be offered that they have rights that must be respected. We need to move forward the two-state solution, living side by side in security for both states and prosperity. I look forward to the noble Lord the Minister's response.
I thank both noble lords and Baroness Northover for their contribution and questions. Can I start with the noble lord's points about Iran and Syria? And of course, Iran continues to destabilize the region through its political, financial and military support for partners and proxies, including Hezbollah and Hamas. And we've been clear that they must cease this support, and certainly long-term peace and security in the Middle East can't be achieved without addressing Iran's destabilizing activities. And of course, President Peshikama has spoken about greater engagement with the West, and for this to succeed, Iran needs to end that destabilizing behavior. I would certainly say that the collapse of the Assad regime has weakened Iran and its so-called axis of resistance, a Syrian-led and owned political transition process leading to an inclusive, non-sectarian and representative government is vital, and that's what we're aiming to support in terms of Syria. And I think our diplomatic efforts to ensure that we judge the new government by their actions and not simply their words. But last week at the UN Security Council, I had the opportunity to meet briefly with the new permanent representative from Syria, and I made these points very strongly, that we are committed to support a new Syria, particularly focused on economic growth that can actually deliver for the people of Syria, and we're absolutely committed to do that. But of course, as the Noble Lady Baroness Northover focused, the main part of the statement was, of course, in relation to Israel-Gaza situation and certainly the occupied territories. And can I be absolutely clear? Because my honourable friend in the other place was very clear. The United Kingdom opposes an expansion of Israel's military operations in Gaza. Continued fighting is in nobody's interests, and we urge all parties to return urgently to talks, implement the ceasefire agreement in full, release the hostages, and work towards a permanent peace and security for Israelis and Palestinians. It is absolutely important that the remaining hostages must be released, and the way to return them safely is through a deal. Absolutely. A two-state solution, and by the way, just to reassure the Noble Lady, Palestinian territory must not be reduced in the conduct of this war. There must be no forced displacement of people from Gaza. A two-state solution remains the only path to a just and lasting peace. And can I just say that in terms of our government's actions, just to reassure the Noble Lady, I hear what she said about the discussions in the other place, but we have been, as a government, absolutely focused on this, and certainly the Foreign Secretary has spoken to Secretary Rubio, the Special Envoy Steve Witkoff, the Israeli Foreign Minister Gideon Saar, Israeli Minister for Strategic Affairs Ron Dermer, the EU High Representative Kelaes, and the UN Emergency Relief Coordinator Tom Fletcher. And of course, the Prime Minister and the Foreign Secretary hosted the Palestinian Authority Prime Minister Mustafa on the 28th of April in London and signed a landmark memorandum of understanding underpinning our strategic partnership and reaffirming our commitment to a two-state solution. Absolutely committed to that. I also, on the 23rd of April, together with France and Germany, the Foreign Secretary issued a joint statement calling on Israel to immediately restart the flow of aid into Gaza, reiterating our outrage at recent strikes by Israeli forces on humanitarian personnel. And certainly I also gave a statement to the UN Security Council on the 28th of April, where I pressed for a ceasefire, the release of hostages, and I also called for an end to the block on aid and a path to long-term peace. And we're certainly putting all our diplomatic efforts into that. And can I just say that to the Noble Lady, our commitment to a two-state solution is unwavering. We are committed to recognising a Palestinian state at a time that has the most impact in achieving this reality and is most conducive to long-term prospects for peace. We are clear, absolutely clear, that does not need to be at the end of the process. And certainly, whilst I was in New York, I spoke to the French Foreign Minister and committed this government's full support to the two-state solution conference that will be held in June. And I think these are the ingredients to that pathway for delivering that two-state solution, working with our allies. And we should take the opportunity to build on the Arab plan for Gaza's future and develop a credible security and governance plans acceptable to both Israel and Palestinians. And we must seize that opportunity. But I would make clear to the Noble Lord, and I have repeated this on many occasions, there is no role for Hamas in that future Gaza situation or for a Palestinian state that is recognised by the international community. Can I also say that we are appalled by Israel blocking aid when it is needed at greater volume and speed than ever before. Israel has now blocked aid for over 50 days, and it is obligated under international law to facilitate humanitarian assistance by all means at its disposal. And we stand ready to work alongside Israel, the UN and our partners to assist. But as the UN said, it is hard to see how, if implemented, the new Israeli plan to deliver aid through private companies would be consistent with humanitarian principles and meet the scale of the need. We need urgent clarity from the Israeli government on their intentions in this regard. But I have obviously reported before our announced package of support for the occupied Palestinian territories, including £101 million for humanitarian aid and support for the Palestinian economic development. We've been absolutely clear in relation to the extension of settlements. We are absolutely clear they are illegal under international law. I hope my comments reassure both Noble Lord and the Noble Lady that we remain absolutely committed to seeking a solution that protects the interests of the State of Israel, but also advances the cause of the Palestinian people.
My Lords, I declare my interests as set out in the register, and I very much thank the Minister for his comments and for the support of the Government. The Government is absolutely right to oppose the expansion of Israel's operation in Gaza and question how the Israeli government's aid plan is consistent with humanitarian principles. According to OCHA, the design of the plan will leave the less mobile and most vulnerable without supplies. And can I ask the Noble Lord the Minister to ensure that the government put pressure on the Israeli government to not only drop these proposals, but also to withdraw their parallel plans to ban humanitarian agencies, including those providing vital medical assistance, if they call for justice or accountability. These agencies and their dedicated staff have years of experience treating Palestinians with compassion and respect, and the international community should insist that aid from these organisations flows freely and without threat or impediment.
I think the Noble Lady is absolutely right. We have been absolutely focused on ensuring that agencies are allowed to deliver aid, and certainly when we had a question on this when we last considered this matter, I made clear that we were ready and willing with all agencies, not just UNRWA, to ensure that we can get aid in when this block by Israel is lifted. We are ready to do that, but we are working very hard diplomatically to ensure that they do allow that aid to get into people who are most in need. By the way, I didn't address the question that the Noble Lady Baroness Northover raised in relation to arms export and international humanitarian law. And of course, this government has suspended relevant